Good afternoon. This is a subcommittee meeting for the Blue Ribbon Commission for the future of the California Bar. Welcome, everybody. This is our fifth meeting, and for the benefit of the public, I'm going to repeat the charter statement. The Blue Ribbon Commission is charged with developing recommendations concerning whether and what changes to make to the California bar exam, and whether to adopt alternative or additional testing or tools to ensure minimum competence to practice law in California. We will be continuing today in a subcommittee format, and the subcommittee that's convened now is considering examination alternatives for a pathway to licensure in California. Before we begin with the business meeting portion, we have an opportunity for public comments. I wanted to go over some of the logistics for that. Public comments will be limited, and members of the public were encouraged previously to submit written comments before today's meeting. And we have received a couple of comments and reviewed those, so thank you for that. In a moment, I will ask the commission coordinator to call any members of the public in the order that they appear. If you are participating by Zoom, I'll go over that method and also by phone. And we ask that you limit your comments to 2 minutes and also not repeat any comments either that you submitted previously in writing or from prior speakers. For those appearing and participating by Zoom, you should have a function to virtually raise your hand. It's a hand icon that should appear at the bottom center of your screen. If you do wish to make a public comment, you can click on that. And anyone participating by phone can click on star or push star and the number 9. It's the star key and then the number 9. And you'll be called upon in the order that you either raise your hand or enter those key functions. And I'll request that any members of the public be called in the order that they submitted their request.
Justice Guerrero, before we start the public comment, can I take the roll call?
Oh, I'm so sorry. Yes, thank you for reminding me.
Sure. Susan Bakshian.
Present.
Jackie Gardina. James Henderson. Esther Lynn.
Here.
Judge Reiser.
Here.
Christine Rossi.
Here.
Mylene Spencer.
Here.
Amy Williams.
Present.
We have a quorum, Justice.
Okay, thank you so much. And again, thank you for catching that. I do want to mention that Dr. Henderson waived, but in case anyone can just hear, he is present here today. So thank you for that. And are there any members of the public who would like to comment?
At this moment, no, I don't see any public comments.
Okay, thank you very much. We'll go ahead and move on to the business portion of this afternoon's agenda. And first, we will begin with a presentation on the use of supervised practice programs in California and other professions. And we're happy to be joined by Marina O'Connor, who is the Chief of Licensing for the Medical Board of California in the Executive Office. And this will give us an opportunity to hear what other professions are doing with their licensing programs. So welcome and thank you.
Hi, good afternoon, and thanks for having me. And I'm just going to go over the licensing requirements for physicians and surgeons in California. It's a little bit more geared towards our outreach events to residents and applicants, but so it might have a little too much detail, but I figured more detail the better. And obviously, if you have any questions at the end, I'm happy to answer those questions. So I'll just go ahead and start. So the next slide, please. So we have 2 main license types for physicians and surgeons. The first is called a postgraduate training license. This is actually a new license type as of January 1, 2020. This is for someone who is going to enroll in a postgraduate training program in California. and specifically an ACGME accredited postgraduate training program, they must obtain a postgraduate training license, what we call a PTL, in order to practice in that training program. They have to meet certain requirements. They have to meet our educational requirements or medical education requirements. They must submit documentation of their enrollment in an ACGME accredited postgraduate training program, and they must have taken and passed an examination recognized by the board. And I'll go over those in a little bit more detail in a minute here. And if they're an international medical school graduate, then they must be certified by the Educational Commission for Foreign Medical Graduates. Next slide, please. So once you go from a PTL to a physician and surgeon, you know, there's additional requirements. So I just have to preface, we actually have another law change coming up this January 2022. So I'm focusing on the new law that's going to go into effect. But what I've done is in the PowerPoint, everything that's underlined is what has changed from current law today to what will be changing January 1, 2022. So I'll, as I go over those underlined points, I'll point out what it's changing from and what it's changing to. So for a physician and surgeon's license, an individual must have completed either 12 or 24 months of approved postgraduate training. And the difference between the 12 and 24 is if you are a US or Canadian medical school graduate, then you only need 12 months of approved training. Whereas if you're an international medical school graduate, you need 24 months of approved training. So what that changed from is today, someone would need, whether or not they're a US or Canadian or international medical school graduate, everyone would need 36 months of approved postgraduate training. But that's changing January 1st. January 1st, it's going to change from 36 months for everyone to 12 or 24, depending on where you graduated from medical school. So that's a significant change in the licensing requirements. And also just as a historical note, that was the same requirement prior to Jan 1, 2020. So in Jan 1, 2020, it changed to 36 months. And now 2 years later, we're changing back to 12 or 24 months. So as far as what's approved postgraduate training, there's a list there in the PowerPoint of the type of training program that is considered board approved. So it must be accredited by either ACGME, RCSPC, or CFPC. So we only accept training completed from a program that's accredited by one of those three entities. A new requirement that's coming up for licenses issued January 1, 2022 is that when they come up for their first renewal, so licensees have to renew every 2 years. When they come up for their very first renewal, they then have to show proof that they have completed 36 months of approved postgraduate training. So even though they can get their license after 12 or 24 months, they still have to complete 36 months by the time of their initial renewal. And of those 36 months, 24 must be completed in the same program. So they could do 1 year in one program and 2 years in a different program, that's fine, as long as they can show 24 consecutive months in the same program. So that 36-month requirement that we have now for initial licensure, it's basically been shifted to the initial renewal. So now they just need to show it at their first time they renew that they've completed 36 months of postgraduate training. And at that point, they would have had their physician surgeon's license for at least 1 or 2 years. So that's a very significant change. That's a new change. That's something we've never had before, is that kind of training requirement at the time of initial renewal. So that will be, you know, an adjustment for folks. Next slide, please. And again, this is a little more geared towards applicants, but you know, this is, when do they need their license? So when you enroll in a postgraduate training program, ACGME accredited postgraduate training program in California, you have 180 days to obtain your PTL. That's that first license you get when you're starting training in California. So they can enroll, and let's say they start July 1st, they can continue in their training program for 180 days without a license. But at 180 days, they have to have a PTL or they have to cease practice. They have to cease clinical practice in their training program. So they do have a deadline by which they must obtain that PTL. If the resident is required to be enrolled in an ACGME accredited training program longer than 12 months or longer than 24 months, then we can issue the PTL for an additional 90 days. So a situation may occur where maybe the resident had to take a leave of absence or a break from training for a period of time, and they weren't able to complete all their training in the 12 months that they would normally have completed in 12 months. We can extend the PTL for an additional 90 days to allow them to complete that 12 months of training. It's basically when will they have obtained credit for 12 months of training in their program, and we can issue that, extend that PTL out a little bit longer. But the law allows us to issue it a PTL up to 15 or 27 months, again, depending on where they graduated medical school. And then in some circumstances, you'll see in parentheses, it says certain conditions apply. We can extend it beyond the 90 days, but it depends on the situation. It depends on why they would need an extension. So if we issued a PTL for 15 months and they said, hey, I wasn't able to get credit for 12 months, I still don't have my 12 months, we would need to know why. We probably would talk to the program, see what was going on. But we do have authority to extend it even beyond that 90 days, even beyond the 15 or 27 months, depending on the situation. So again, as I mentioned before, if the PTL expires, they have to cease practice. They should have obtained their physician surgeon license before their PTL expires. If they have that 12 or 24 months credit, they should have applied for their physician surgeon license and be going through that process so that they can obtain their physician surgeon license before their PTL expires. Thank you. Next slide. And this goes into a little bit more of the details of the application. Again, might be too much information, but they of course have to submit a form, a fee, they have to be fingerprinted. For those international medical school graduates, we look for that ECFMG certification status report that shows that they're ECFMG certified. And then we do require official examination scores from the appropriate examination entity, which is mainly the United States Medical Licensing Examination, what we refer to as the USMLE, or they could have taken their exams from the Licentiate of the Medical Council of Canada. So those are the main two examination entities. There are exams that were offered a long time ago that are no longer offered that the board may accept. We have in our regulation, it specifies what combinations of the old exams we'll accept towards licensure. It's a very long list. There's a lot of different combinations of old exams, but those are for folks who maybe took their exams a long time ago, maybe practiced in another state, and they're just now coming over to California. But most of our folks have taken the USMLE or the LMCC. The USMLE is the most common exams, obviously for US residents. And we only accept scores from within the last 10 years. So if the exam was passed more than 10 years ago, it's technically considered expired. But we do have in our statute the ability to extend the validity of exams. So one example would be if they passed the exam more than 10 years ago, but they've been practicing as a physician and surgeon in another state, we can extend the scores for that time. We can say, okay, well, it's been more than 10 years, but since that 10 years was up, you've been maintaining your practice, you've been practicing in another state, we could potentially extend those examination scores. So again, it's case by case, depends on what the situation is, and the statute's pretty specific on the situations, the scenarios when we can extend those scores, but generally they need to be within the last 10 years. And just to go in a little more detail on the USMLE, it's currently a 3-step exam. In order to obtain a PTL, you have to have passed steps 1 and 2 CK. There used to actually be, for step 2, there used to be, say, 2 sections of step 2. There used to be a step 2 CK and a step 2 CS. The step 2 CS was a clinical exam, which required in-person examination. And because of mainly because of COVID, they stopped offering step 2 CS. And the USMLE folks actually decided to just discontinue it completely because they did not believe it was an effective way of measuring someone's ability to practice and competency. So they're reevaluating how they want to administer that type of test in the future. But for now, it's 3 steps. It's step 1, it's step 2, which is technically step 2 CK, and step 3. To obtain a PTL, you need to have passed steps 1 and 2. Now, when you come around for licensure and you want to obtain your physician surgeon license, you have to have passed all 3 steps. So we're looking for that 3rd step to have been passed before we issue a physician surgeon's license. Next slide, please. And some additional documents that we require, a timeline of activities, and the note there that if they've graduated within the last 6 months, we don't need a timeline of activities. Explanation for application questions. It depends on how they answer some questions on our application. We may require additional explanation for that answer. And then license verification. If they're licensed in another state, we do require license verification from that state. It can't come from the applicant. That state has to send us verification of the license they hold or held in another state. Next slide, please. So of the documents that are required, I had mentioned medical school documentation of, completion of medical school, which it would be in the form of a transcript and a certified copy of the medical school diploma. We have an additional form, which we call a certificate of medical education. It has to be completed by the medical school, and they fill out their information, but they also answer a few additional questions. And then additional documentation from the postgraduate training program, again, has to come directly from the postgraduate training program to the board to be accepted. There's a form that they must fill out. It's called the PTA PTB, where they basically outline, here's all the training the applicant completed. Here's how many months they received credit for that training. They also have to answer a series of questions such as, did the resident take a leave of absence? Was there any point of time they were placed on probation? Questions such as that they must answer on that form. And then if they are they're currently enrolled in a postgraduate training program, they would need to submit the postgraduate training license enrollment form, which would show us that, hey, I'm currently enrolled in a training program. And that's mainly for the PTL. To issue the PTL, as I mentioned before, we need to have proof of enrollment in an ACGME accredited program. Next slide, please. And I had mentioned the transition from a PTL to a physician surgeon license. And so this is just a little bit more detail about that application. Again, of course, we're looking for, at least starting January 1, looking for at least 12 or 24 months of completed training. There's a form they must submit, an application form, a fee, again, showing proof of completion or passing of USMLE step 3, all of the training documents that we need to show, that they would need to show completion of the required months of training. And then there's a note there, again, regarding the renewal requirement that starting January 1, when any license issued Jan 1, 2022 or later, they must show proof of 36 months at the time of their initial renewal. Next slide, please. Any questions? That's it. I know it was a lot of information in a short number of slides. I know there's a lot more nuances to the application depending on how folks answer questions on the application, if they have prior discipline or convictions, because we do require fingerprints. But that's basically the licensure process in a nutshell for physician surgeons in California. So I'm happy to answer any questions.
Thank you so much. That was informative. I was learning a lot of acronyms.
Yeah,
that
I
I'm not
apologize for all the
familiar
acronyms. Yeah,
No,
we like those a lot.
thank you. Thank you for the presentation. I'll open it up to questions, starting with Judge Reitzer. You're on mute.
There were a lot of acronyms that I got caught up with. But so my question is really with respect to all of those licensure requirements, how many of those are written examinations and how many of those are sort of, physicians with patients, practical exams, if you will?
Sure. The main exam, the USMLE, the United States Licensing, USMLE, sorry, United States Medical Licensing Examination, that one is mainly written. The part that they discontinued was the clinical portion, the Step 2 CS. That used to be part of that exam, but due to COVID, and I believe there were other concerns with the efficacy of that exam, they discontinued it. I think it was as of July 1, it was around July, June of this year, they discontinued that step. So the other steps that they have to complete are written. They're all written. I can't speak to the Canada exam, the LMCC. I don't know specifically what portions of that, if any, are clinical. But I can certainly, I'm happy to get back to you and provide that information later.
And with respect to the written portion,
Mhm.
is it more than a day, more than 2 days? Is it 3 days? Is it essay? Is it multiple choice?
Sure. I can bring up the details. We don't administer the exam, but each step is slightly different. It looks like step 1 is a 1-day examination. It looks like it's got 7 60-minute blocks administered in 1 8-hour testing session. Step 2, which is step 2 CK, is also a 1-day examination. Similar to step 1, 8 60-minute blocks, but it's over a 9-hour testing session. And then step 3, it doesn't say how long you take. It's basically a panel, a committee. It's the final assessment of the physician. So I don't know if it takes more than 1 day or not, but it looks like it's more of a, probably a presentation and Q&A and discussion, probably some discussion pieces as well and written. I'm sure it's a combination of things, but yeah, that's what it was before they discontinued Step 2 CS, which Step 2 CS was the in-person clinical portion.
So, and one last question. So when you say that this last segment is before a panel, is the suggestion that there is perhaps a dais of physicians who are presenting questions to an applicant, and the applicant is responding to inquiries?
So I don't know the format, if it's like live or if they submit if they submit something and then the panel reviews it and submits questions back to them. I don't know the exact back and forth. I just know it's a panel or committee that comes up with the questions and material. And I believe that it's a little bit individualized, but I can't say for sure the exact format of how they do it, but it is a group of folks that come up with the questions, and they do kind of a final evaluation of each physician.
Thank you.
And I'm happy to provide you more information on that as well after this meeting, no problem.
Thank you. Dr. Henderson?
Found the unmute button this time. The questions that I have, I'm really interested in the training programs themselves. How are they administered? How comparable is the training that one physician receives as opposed to all of the others? And what strategies are used in the assessment of learning through that training program?
So the training program must be, at least the US training programs must be accredited by the Accreditation Council for Graduate Medical Education. That's ACGME. They set all the training standards. So they have specific standards that these programs must follow and meet and renew, of course, for their accreditation. But I can't say to what degree they differ. I mean, it's of course by specialty and program area. There's going to be differences, and there's differences in length. They're anywhere from 3 years to 7 years, depending on the specialty. And some programs even incorporate research into their training programs, all of which has to be approved by ACGME in order to keep, that accreditation status. And then there's even some specialties that do what you call a preliminary year. So they do, I guess it's some kind of, some area of like general medicine in a preliminary year before they even can go into their specialty program. So they'll do a year, maybe even 2 years of what they call a preliminary program, and then they'll have to apply and transfer into a specialty program after that. So it depends. It can vary greatly by specialty, but the overall program components and requirements are all standardized by ACGME. And even as so far as what's allowable leave, how much leave can a resident take? When can they take it? How do they get approval for that leave? Those are that's just one example of, the kind of standards ACGME sets for the programs. But, there is the variance across specialty. And the research portion, there's even variance across the research portion. Some programs have their residents do an entire year or 2 of research in the middle of their training, and some do it sparingly, where, okay, we'll do a month of research here, a month of research there, a month of research here. So it can differ in that regard as well.
So I'm curious if, I guess, given the differences due to specialty, mostly it sounds like, right?
Correct.
The actual, so within a specialty area, I assume that the curriculum in these training programs is standardized, and the assessment of learning is also reasonably standardized. Is that a fair statement?
I could not say that exactly. I'll say the curriculum is my understanding is the curriculum's as standardized as it needs to be for them to show at the end of their program that they can practice that specialty competently. And it's up to the program to make that final assessment, but the program, when they do their final assessment, it does have certain requirements in that final assessment, certain things that they have to check for and test for. So I guess what I'm saying is there's a standard process and kind of minimum of what they should be checking for, what they need to be ensuring that resident can do and complete and has knowledge of by the end of the program. I think there's some flexibility in how they go about doing that as far as a timetable, what they practice in their first year, what they do in their second, what they do in their third. But the end goal is the same, that they have to meet these competencies, and the program has to measure those competencies following a basic standard of measurement, and ensure that they meet them by the end of their training. So I know that doesn't answer it exactly. I can't speak to it any more in detail, but I'm happy to share with you folks ACGME's requirements for their programs. That goes into a lot more detail on, it's quite long, but what they require of their programs to be accredited. And it speaks to, the final assessment, what they have to test for and check for and how. But it allows, I think, enough flexibility for the program to adapt their program to their needs, their resources. At least that's my understanding.
You have no need to apologize for your answer. It's really good. Thank you.
Okay.
One last question, and it should be maybe easy, and that is, how many people are in training at any given point in time?
There are roughly 3,000 ACGME accredited residency spots in California. I can't say outside California, sorry. But California is one of the largest number, actually, I think we are the largest number of ACGME accredited residency spots of any state. So we have about roughly 3,000. I think it's actually a little bit more in California. But I do want to point out there's also non-accredited residency positions. There's fellowships. Some fellowships are accredited, some are not. And while we don't count non-accredited residency positions towards the licensure requirements, so we don't have as much interaction with those folks. My understanding is it's those positions, those non-accredited positions, are typically for folks who maybe have completed a specialty, but are completed their program, but are learning something else, learning something new, something in addition that they don't need for meeting licensure requirements, and they might not even need it for board certification. But it's just it's another area that they're going to either learn or assist with, and it's all based on funding, which this is where I get really outside my realm. Is the number of ACGME accredited positions is all based on funding, and the number of positions any one hospital or clinic has is based on excuse me, the funding they have for those positions. So I believe the non-accredited positions are not funded. So they're they don't have very many, of course. They're for folks where I think my guess is the hospital or clinic has to fund it completely on their own for any non-accredited residency position, which is why I don't think there's very many, and they're probably very specific for something very specific they want this person to learn or to help with after they've completed their program. But that's kind of where my knowledge of the non-accredited positions end. I hope that answered your question. Sorry.
No, you did. Thank you very much.
Thank you. Susan, you're next.
Thank you. I have two, I think, short questions, one about the application process and one about completion rates.
Sure.
First, on the application process, I noticed that you have down, of course, fingerprinting is required. And you mentioned that the applicants and the schools fill out applications, but I'm trying to get a sense of whether or not you have anything more the equivalent of what we do in terms of moral character and fitness approvals, where we ask everywhere you've ever lived, everywhere you've ever worked. Is that part of this process somewhere along the way?
So as close as we get to any kind of character assessment, we rely heavily on the postgraduate training programs and the medical school. So, the basic assumption is you graduated medical school, you learned what you needed to move on to a residency, you passed and successfully completed the required months of your residency, you're most likely competent for licensure. However, I had mentioned on our applications, we have a series of questions that ask, were you placed on probation? Were you terminated from a program? Did you take a leave of absence? That's where we get more into competency questions. The only time I'd say character questions come up is professionalism. We actually have in our statute, we can deny applications who don't meet our standard of professionalism, which is very broadly defined. And we really, again, rely on the postgraduate training programs to tell us, have they met your professional standard? Because if they haven't, we would likely have seen some type of probation or remediation that had to take place, potentially a termination, or a lot of times programs will not renew their contracts. So they're typically annual contracts for these residencies. So if they, let's say they're enrolled in a 3-year program, they have to renew their contract every year for that 3-year program, and a program can decide not to renew them. They could say, hey, you did your first year, but you didn't do that well. We're going to give you credit for it, but we're not going to renew your contract. And they would have to go find a residency program somewhere else. So it's largely dependent on the programs answering those questions, notifying us of any issues that came up during their training. Same thing during medical school, if they had issues during their medical program, medical education program, did any issues come up? But we're very limited in statute what we can deny an application for. And so the closest comes to that professionalism standard, which again, we mainly rely on the programs. But the only exception to that would be any arrest or convictions we're made aware of, any disciplinary history in another state. That's on us to evaluate. We'll have to look at that, any kind of disciplinary or conviction history, and determine, does this jeopardize their ability to practice medicine safely in California? That's the ultimate question at the end of the day. And we will have to evaluate that on case-by-case basis. And according to, does it meet the requirements of our statute, or does it meet the criteria for a potential denial or probation? We can offer probationary licenses for any number of years. We can place an individual, issue the license on a probationary status, where they have to complete, or I should say meet certain requirements, which could require completion of additional courses, such as an ethics or professionalism course, if that was an issue. If there's substance abuse problems, we can require substance abuse treatment and programs. It's again case by case, and it depends on what information we have at the time. Some of which the applicant is required to tell us, and some of which is not. So I'll mention there was a law change July 1, 2020, that significantly limited our ability to obtain that type of information, like history of prior discipline, or not discipline, it's mainly convictions, history of convictions. Anything older than 7 years, we can't even look at or consider during the application process. And that's as of July 1, 2020. If it happened, if there was a conviction or arrest or a discipline taken outside of 7 years, we can't touch it or even consider it unless it was in violation of very specific penal codes. Anything inside the 7-year time frame, the applicant is not required to disclose it to us. So they could have had a conviction, they could have had an arrest, they could have had any number of things. They do not have to tell us about it, which is why we heavily rely on the fingerprinting and the postgraduate training programs to tell us if anything came up. So unfortunately, it's a lot more limited today than it was prior to July 1, 2020, and what we can require, what information we can require from the applicant. And one thing, again, I apologize, this is too much information, but one significant change for us in that law, July 1st, 2020, was that prior to July 1, 2020, we could deny an application just based on dishonesty itself. If an applicant answered a question dishonestly on their application, we could, of course, substantiate it. We could deny the application. We can no longer deny an application only for the sole reason of dishonesty. There has to be some other reason we would deny the application for. So let's say they were dishonest about answering whether they had a prior conviction. Well, if that prior conviction was significant and we would deny the application based on that conviction, then we can also deny it based on dishonesty if they were dishonest about it. But if that conviction wasn't enough to deny the application, but they were dishonest about it, we still have to approve the application. But even though they were dishonest, if that conviction was not anything significant enough or related to their medical practice, and we wouldn't deny it based on that conviction, we cannot deny it just for the dishonesty itself. So that was a big change for this board.
Thank you. That's very helpful.
Sure.
And my second question was to ask, and you touched on this a little bit when you talked about sometimes folks are non-renewed during these training programs. I'm wondering if you could talk to us at all about completion rates. Obviously, these are folks who have already paid for and finished and invested in medical school and are now in this training program. I'm assuming it varies greatly by school, but I'm wondering if it's as fluid as law schools that can have, very low passage rates on bar exams. How does it compare, so to speak, to these training programs and their expected completion rates?
I apologize, I don't have any statistics for you. I could see ACGME keeps a lot of those types of stats on their website, but I can tell you anecdotally from the applications we receive, it's a pretty small number of folks that are not renewed for their training programs. It's an even smaller number that's terminated. I mean, very small number of applicants are terminated from their training programs. The non-renewal, a little more common than the terminated. but again, not very often. Most folks are renewed. Typically what we see, if they had issues in their first or second year, the program works with them to remediate those deficiencies. There's an incentive, of course, for the program, because they're investing their time and resources in training this person, and for the applicant to complete the program successfully. So, that's when you'll see them maybe put on probation, or maybe they'll make them make up some rotations. So they'll take a little longer than 12 months to complete what they would have normally completed in 12 months. They have, these programs have a clinical competency committee. And I believe that's actually required by ACGME, where they review these cases. So these residents who are struggling, they get reviewed constantly. They're reviewed quarterly, annually. If they have issues, they're reviewed more often than that. When they come up for a review, if there's any issues, they're giving them a remediation plan. They're saying, here's the issues we found, and here's what you need to do to remediate these issues. You need to do more, chart reviews, or you need to, maybe someone's just being tardy. We see that you're not responding to your pages. You need to be more responsive. They'll outline for these residents very specific plans, or maybe they say, you need to, you have a big knowledge gap in this area. You need to go, study more, on this subject. So they stay on them during the residency, because if they are struggling, they want to, help them, be successful and complete that training program. So there's a strong incentive to keep them on and keep working with them. It's pretty, when we see a termination or a non-renewal of a contract, it's usually for a significant reason. And what's interesting is they can often find another residency program that will take them, even though they had a termination or a non-renewal. And what we often see in those cases is sometimes it's just not a good fit. Sometimes, the resident is in a program and it's not a good fit, either for the people they're working with, the profession, or maybe the specialty. They may even change specialties, be like, what, radiology is not for me. I want to go into family practice. That can happen. We kind of see of course, the full gambit, but there's a lot of differences and reasons why people may change programs or transfer or leave a program or not be renewed and continue on with their training somewhere else.
Thank you.
You're welcome.
Thank you. Amy?
That actually answered one of the questions that I had, because I can't imagine that these continuing programs, these practice programs in other professions, let's say the medical profession, someone is going into oncology, then, all of a sudden is privy to be able to practice obstetrics or urology or, endocrinology. So for me, I think what's most important to me is that if these programs are geared specifically for a specialty or a specific area of practice, I think that is able to be, there's more control over that process, over that admittance process, in my opinion.
Mm-hmm.
Damien, I'm done speaking.
Yeah, and one thing I should have brought up is, and I mentioned it briefly, but it was, so board certification. So there are specialty boards that certify physicians in their specialty. So we don't license based on specialty. When we license someone, we're saying you can practice, you're free to practice the full gambit of what is under the scope of practice of a physician surgeon. It's actually on the industry and board certification to kind of regulate what they should be practicing. So, hospitals and facilities, they require board certification for those types of specialties. They say you need to get that, certified in oncology or whatever it is, if you want a job with us in doing oncology. And those boards, that board certification has its own requirements that are way more, specific. They're like, you need to have completed X number of rotations in this and X number of rotations in that and this many months doing this. It's very specific what they must complete. So when a resident is going through their training program, they're having to meet technically 2 requirements: our requirements for licensure, and then the requirements for board certification in whatever specialty they're going into, which is board certification. I say board, not our board. It's the specialty boards that are completely outside our governance and regulation. You know, they have their own regulatory body, but they also, the programs are also trying to make sure that these residents are on track to become board certified. Because the way I understand it is they're likely not going to continue on with any kind of permanent role there in a position if they don't get board certified. And they'll have a hard time working in that specialty without board certification. And in fact, it's I won't say it's impossible, but it's not easy.
Thank you.
You're
Next, Donna.
Yeah, thank you. Marina, this has been really, really helpful. And I just want to take a second to sort of step us back through the timeline as this subcommittee is really thinking about, you know, should we be eliminating the bar exam as it exists today and instead creating a, for purposes of comparison, a residency program. So I just want to make sure that we all have sort of a good understanding of how this works. So I'm just going to sort of start talking through the process and ask you questions sort of as I'm going. So as I understand it, individuals in medical school, and so they graduate from medical school. Do they need to take an exam? Is there a standardized exam at that point upon graduation before getting into the ACGME certified accredited postgraduate training program?
That's a good question. So most, I'll say most, maybe all, U.S. medical schools require passage of steps 1 and 2 of the USMLE in order to graduate. I can't speak for international medical schools. I don't think they all require passage of those steps. I've seen it before where by the time they go into their residency, they have not passed step 2 yet. So I know there's schools out there that don't require step 2, although I don't think they're very common. And I think they're mostly international schools. But yeah, most US medical schools do require passage of steps 1 and 2 just to graduate.
Okay, so that's a requirement of graduation from the school. So they take those exams, then they get their degree having graduated from the medical school. At some point, presumably during, I'm going to guess, their final year of medical school, they are applying to these ACGME accredited programs. So first, do you have a sense of, because you said there are about 3,000 seats, how many programs are there out there?
It depends on if you go by specialty or I want to say program. So each program has each ACGME accredited program has an ACGME number. I would guess, I have never actually looked up how many total there are, but I would guess there has to be thousands, because one facility or like a school, like a UC, for example, could have hundreds. So I'm going to say in the thousands is my guess. I apologize, I don't have an exact number, but there's a lot, because because you narrow it down by, you can narrow it down by specialty. And you know, if one, I mean, there's so many different just so many different specialty areas. You know, there's specialties within specialties. Right. So there's a lot of different, there's a lot of different, areas of practice they can go into, and then each facility or entity can have, one program, 2, 100. They can have quite a variation there.
And so you graduate and you apply to these programs, and there are about 3,000 seats. And how does that compare to the number of people who graduate from U.S. medical schools or California medical schools? My question basically being, is there a seat for everybody who graduates, especially everyone who's passed the step 1 and step 2 in order to graduate? Is there a seat in one of these programs? And if not, then what do they do?
So if you combine the US medical graduates and the international medical graduates looking for a residency spot in California only, no, there are not enough seats for everyone who wants to enroll in a residency program in California. Absolutely not. There's not enough. There's even, I had mentioned the whole preliminary year before going into a specialty program. There's even issues there where someone can start their preliminary year and not get into a specialty program. Again, just because of sheer numbers, there aren't enough spots in the specialty program for all the people who did a prelim year to go into one. And they have to repeat their prelim year. They have to do another prelim year. It's more common in certain specialties. There's some specialties that just have very limited number of spots, and there's a multitude of factors. I mean, the area they're in, the demand, the need, the resources available, etc. Right? The list could go on. Why they would have any number of residency spots for that specialty available, but I want to say it's I forget off the top of my head. I want to say it might be audiology. That's one that we see that is tough for folks to. There's not enough. We often see them repeating their prelim year before going into. It's one of the audiology programs. So yeah, that's a definite issue in California. I can't speak for like the U.S. as a whole or their states. And if you were just looking at U.S. graduates only, trying to get into a California residency spot, I would still say there's not enough. My guess is there would still be not enough. I mean, folks can, are looking at other states, of course, and some folks even go internationally to train. What they'll often do is if they can't get into a ACGME accredited position in the US anywhere, they'll even look internationally just to continue practicing, just so they can continue to practice, even though that practice won't count towards licensure. We don't see as many applicants that go that route, but we do see them. It does happen.
And so to back up a second, because you'd reminded me of the preliminary year, that's optional, or that applies for some programs, but it's not. Some people can go straight from medical school into the postgraduate training program.
It depends on the specialty. So some specialties say do a prelim year first and get some general, clinical training in general areas before you come to our specialty. And some will incorporate that prelim general, practice into their program. So it'll be a 3-year program, and their first year will be concentrated on, the more general areas and whatnot before maybe getting into the specialty stuff. But it just varies. Some will separate the program. You do your prelim first, then you have to apply to the specialty, and some incorporate it into the program.
Okay, so then at the end of their 12 months, their first 12 months of postgraduate training, then they can submit an application to the medical board and say, I've done my, let's use an example of somebody who did their step 1 and step 2 in order to graduate from medical school. So, right, I've graduated from medical school, I've done step 1 and step 2, I've done 12 months of a postgraduate training program. Hand me a license? Is that like, or is there a test now that the Medical Board of California requires?
So as far as for a postgraduate training license, the PTL, right, it's just graduate from medical school, pass steps 1 and 2, complete forms, get us all the documents. And yes, you get your PTL. And again, you don't need the PTL till 180 days after you've already started your residency. So they're already in there. A lot of them, they don't, not all, but a lot of them will start their residency and then apply for their PTL. Some residency programs require them to get a PTL before they start their residency, and some don't. So it depends, it's up to the program what they want to require. But the board, we require it within 180 days of you starting that residency, you must get your PTL. Did that answer your question?
So your PTL requires you to have 12 months of study. Then you go into a residency program, which is the 1 to 7 years. Is that?
So the PTL is you don't have to have any prior training. You could have had a year in another state, or you could be starting from the very beginning, your first residency in California. But if you want to train in a California residency program in California, and you don't meet the physician surgeon license requirements, right? You don't have 12 or 24 months, you're going to need a PTL to do your residency. You're going to need it to practice. And then once you get your 12 or 24 months, then you apply for the full physician surgeon license.
And then at that point, once I have completed my 12 or 24 months, I've submitted all the forms, I had done the step 1 and step 2 in order to graduate from law school. You say, okay, you've met all the requirements. At that point, I can put DR in front of my name, and I can hang out a shingle and practice on my own.
You can actually put DR in front of your name when you're in a residency program. It doesn't actually require a physician surgeon license. It's more of a scope of practice. I'm trying to remember the statute. It's mostly like if you're practicing under the scope of a physician surgeon or PTL within the scope of this, practice, you can call yourself a doctor. You have to have an, MD, of course, but or DO. Yeah.
But at that stage, I can't practice except under supervision of a program during that first period. But after I'm licensed by you, then I don't need supervision anymore.
That is correct. That is correct. Once you get a physician and surgeon license, the full license, you don't need to stay in your residency program. However, if you don't complete your residency program, you're not going to get board certification and likely not going to get a job anywhere in California. At least I could probably say very unlikely. But yes, that is correct.
Perfect. That really helps. Thank you, Marina. I appreciate it.
Sure. Yeah.
Thank you. Are there any additional questions? It doesn't look like there are any further questions. So thank you so much for this very informative presentation. We enjoyed learning about your program.
You're welcome. And feel free to send any additional questions my way. I'll try to find some of those stats folks were asking for and a little bit more information on ACGME's requirements for their accredited training programs. I can send that your way too.
Great. Thank you. We really appreciate your time here today.
All right. Thank you. All right,
Bye.
Take care. Bye.
The next presenters can only join us at 3. So we'll go to the item C or the next item on the agenda, which will be a discussion from Amy about what we've learned about California's provisional licensure program. Amy?
Yes. Hi, good afternoon, everyone. I'm going to share data that we have related to the provisional licensing program. And so with that, I'm going to ask to share my slides. There we go. So just as a background, I want to tell you a little bit about the program so we're all on the same page about what it involves. So next slide, please. In October of 2020, the Supreme Court approved California Rule of Court 9.49. This implemented California's first provisional licensure program that became effective in November of last year. The program initially was targeted to 2020 law school graduates, which it was in response to the pandemic, and it specifically allowed those that met all eligibility criteria for admission, with the exception of having passed the bar exam, the ability to practice law under the supervision of a supervising lawyer. They also have had to either received a positive moral character determination or have submitted that application. And if they had not passed the MPRE, the multi-state professional responsibility exam, they could substitute the ethics portion of the new attorney training in lieu of passing that. And the idea was that applicants, that exam requires going to a testing center, and this was at the height of the pandemic. So the idea was this was a temporary solution. The MPRE would have to be met once an applicant was able to take that in person at a test site and before getting fully licensed. In January of this year, the California Supreme Court amended California Rule of Court 9.49. And in this amendment, the court approved the expansion of widen the eligibility for this program. And what the expansion did is it made it possible for potentially 2,000 bar exam applicants who achieved a score of greater than 1390, which was the new cut score, either achieve that at either the first read or as a total scaled score between July 2015 and February 2020. It allowed those applicants the ability to serve as provisionally licensed lawyers. One thing also is that these candidates, unlike the 2020 graduates, would also be eligible for licensing after 300 hours of work as a PLL, along with a positive referral from their supervisor. And that would be in lieu of passing the bar exam. So all other requirements would have to have been satisfied as well. There was one more amendment that happened in March, and that was really to clarify the eligibility criteria for the expanded pathway. Specifically, applicants who have passed the bar exam but had not been licensed yet were not eligible for this program. And applicants with adverse moral character determinations were not eligible for the program unless more than 2 years had elapsed from the date of the final determination of the moral character decision, or after some time that was set by the state bar for good cause shown. Now, next slide, please. In terms of the statistics, I want to highlight here that there's 3 sets of numbers. The first set of numbers is just to give you a sense of the number of applications. So the number of applications that have been accepted into the program are categorized in 2 separate categories. I mentioned that the first criteria, or the first eligibility criteria, is related to graduation date, those that graduated between December 2019 and December 2020. And then we also have those that qualify for the program under the program expansion. These are our sets of numbers of the people who have been approved, suspended, terminated. The first set of numbers here, 1,124, refer to the number of applications that we've received from the graduating cohort, and those that qualify under the program expansion, we received about 804. Applicants are required to add information about their supervising lawyer. The supervising lawyer has to sign that application. Part of sometimes why we have multiple applications from one applicant is because there's a signed application for the multiple supervisors that somebody might have. So as you can see here, we have 1,124 applications from the graduating cohort, 804 from the program expansion. If you look below that, this is a number of current people in the program. We have 332 that are currently practicing under the supervision of an attorney, a California attorney right now. And then also under the program expansion, we have 397. One thing I noted about the program expansion is that this allowed or facilitated the ability for people who are in the expansion program, the ability to get fully licensed after 300 hours and a positive referral. To date, we have 308 that have been licensed, and that's the last number in this chart. Next slide, please. In terms of the demographics, I have 2 sets of to show you. This is the race and ethnicity breakdown of those that have participated in the PLL program. And as you can see here, the highest category is white, followed by Hispanic, Latino, or Spanish. Next slide. In terms of law school type, majority of candidates participating in the program come from ABA accredited law schools in California, followed by CBE accredited law schools. Next slide. And in terms of gender, the program, in terms of applicants participating in the program, females there are slightly more females participating than males. The next slide, I mentioned there are 308 applicants that have been admitted to the bar. This is that racial background, race and ethnicity background, and it really reflects those that are participating. Predominantly, we have 129 white. Here, this next category is Asian. Next slide, please. In terms of school representation of those that have been admitted to the bar through the PLL program, we have ABA accredited law schools is the highest category, followed by CBE accredited. Next slide. And here we also see that it's primarily females that are admitted. Next slide. We polled a group of applicants that had started their application and never submitted their application, approximately 124, to determine why the application had not been completed. Really reasons for not pursuing the PLL program once they've drafted and prepared an application. And these were the top reasons why. Difficulty finding a supervising lawyer. The process for applying was burdensome. Some applicants identified as not having, they didn't have the time to spend the 300 hours of supervised practice. Others could not afford to spend 300 hours in supervised practice. Also, next slide. In the breakdowns that I provided, there were terminations that have been included here. And the primary common reasons for terminations include somebody's either been admitted to the bar or they're no longer employed or supervised. And that includes reasons like somebody's jobs ended, applicants requested to withdraw, or possibly even took another job. One of the questions that's come up too is how long, next slide please, how long is it taking for applicants to go from being approved to getting fully licensed of those that are in the expanded pathway? So this next set of data looks at how long it's taken in terms of months to go from being approved in your application to actually being admitted. So this is time from approval to admittance date. And the average takes anywhere from 4 to 6 months. As you can see here too, the longest it's taken is 7 to 9 months. All right, now with that, I wanted to open it up and see if anybody had questions about the PLL program. Yes, Dean Bakshi.
It's just professor.
Okay.
You guys promote me every time I'm here. It's quite great to see you. But no, thank you. I just had a quick question on the PLL program. I know the applicants have to have moral character approval. Did we see anybody rejected for moral character or for something that we would consider the equivalent of disciplined?
I think yes, we've had to suspend applications in that as part of the review process. That is when somebody got referred to OCTC as a consequence of when discipline investigation started. Yes, we've had some.
Would we know if it's a higher rate than we would see in the ordinary population of new admittees?
We have not been able to conduct that level of research. It's very soon in the program.
Amy, on the slide about the, first, thank you so much for
Sure.
the information. On the slide about difficulty finding the supervisors, were you
Yes.
able to obtain any data on the composition of that group?
We have data, but the cells are very small. I mean, it's a very small group. I mentioned that there were 124 that we reached out to, And so reporting on the race and ethnicity or the composition, any demographics, that the small sample size made that challenging.
Okay, thank you.
Sure. All right, thank you.
Thank you again, Amy. Oh, Susan, you have a question?
Sorry,
It's fine.
just one quick follow-up. Do we have any sense, I know that you had talked about that some of the incomplete applications were because they found the process burdensome. And I'm curious about that because I heard personally from an awful lot of grads who thought the process was actually rather simple. So I'm not sure where we have a little disconnect there.
Yes, we agree. I mean, the process is fairly easy. If anybody has applied for moral character, registered as a law student, applied for the bar exam, or participated in any of the applications or submitted anything with the Office of Admissions, in terms of the burdensome, in terms of the application itself, it took maybe like 3 clicks to prepare that in the AIM system. And what I imagine by burdensome, it could be ensuring that everything else had been in place, because while your moral character did not have to be approved, it had to be submitted, and perhaps gathering that could have been a problem, or even and like I mentioned, the other only caveat was the MPRE. You did not have to have achieved a passing score yet. You had to have met the, if in lieu of that, you could have taken the professional ethics portion of the new attorney training. The issue with that is you also could have done it while you were in the program itself. You didn't have to do it prior to joining on as a PLL. So we're baffled by that as well, as what portion of that could have been burdensome.
Thank you.
Sure.
And we did sort of delve down a little bit into the questions like, for those who found it difficult to find a supervisor, we asked follow-up questions in terms of, did you join the California Lawyers Association PLL community? Did you reach out to a regional bar association? How many hours did you spend sort of in those endeavors? Just trying to get a sense of were people spending, hundreds of hours trying to do this, reaching out to all of those sort of possible resources, and were simply unsuccessful, and just could not find someone, because part of the information that we wanted to identify, which unfortunately the numbers, as Amy said, were too small, but would we find some commonality in terms of those who really spent a lot of effort, but were unable to get a supervisor? Would there be some commonality based on demographics? Would there be commonality based on the type of law school from which they graduated? What would be some of the factors that we could ascertain from that? And so that's why we went into more specifics on those questions. But I did want you to know that we didn't sort of leave it at the, did you have difficulty? Oh, okay, moving on now.
And sorry, and speaking of which, in terms of what people found burdensome, of the follow-up open-ended responses that we received, the common theme between them was identifying a supervising attorney.
Thank you. Mylin?
I guess my question is is very general. Are these the numbers that you were expecting from this endeavor generally? And if I read and heard the slide right, the 1,100 number is the folks who had started the application, right? And then some of them fell off, and that's where you did your research. But what was the number of folks who were eligible to participate?
I think that's, we knew the number of eligible applicants of those that in the expanded pathway. We knew how many people had achieved the 1390 at first or second read for those five exam cycles. What we didn't know, or 5 years of exam cycles, but what we don't know is the number of 2020 graduates, because we could have people from other states, from other countries that qualified to sit for a bar exam and practice in California that have participated. So that was an unknown population. And so in terms of what we anticipated, I think what we anticipated from the the only ones that we could have a sense of that or forecast is for the expanded pathway. As for 2020 graduates, that application has not closed for 2020 graduates. The program ends in 2022, June. And so that is one that's unknown, but we,
There were, I think, Mylin, there were theoretically over 2,000 people who were eligible, who had between a 1390 and a 1439 in that 5-year period. Certainly what we didn't know is how many of them have moved on from the law. Right, so that was a complete unknown to us. So we just couldn't have that sense of how many people would be applying, but it was over 2,000 that were eligible.
Sorry, this is a slightly different but follow-up question. In terms of the difficulty finding the supervising attorney, I know that I was contacted by some former students wanting to participate, and my sense was that it was ad hoc and I didn't even know about the CLA option. Were there clear methods to match supervisors with applicants? Or was there a dearth of supervisors generally, or was it just that it was too hard to coordinate all of that?
Yeah, it was really difficult to create a matching program. The State Bar participated in a webinar with California Lawyers Association to get the word out to everybody who qualified, was eligible for the program, about the community that CLA established. CLA provided free membership to CLA for those people who wanted to participate in the PLL program. Anybody who'd reached out to us, we referred them to CLA. We suggested regional bar associations, but the State Bar itself did not put together a matching program, and you wouldn't have been able to do so in the limited time that we had, and may or may not have been able to do so if we had a significantly longer period of time.
But also the State Bar recently engaged in providing grants to legal aid organizations that hired PLLs. So we tried to incentivize the recruitment of PLLs as much as we could.
Okay, so a third follow-up question that may be impossible to answer, but of course, I think where we're all going with this is like, could this be scaled, right? What's your sense as having done a little, this is a pilot, what's your sense of the possibilities and challenges of scaling?
And when you say scaling, Malin, you refer to providing this to all, graduates from California or worldwide, the ability to participate in a PLL as a method of becoming licensed? Yeah,
I mean, to the extent that we're the non-exam pathway subcommittee, this could be a piece of that non-exam pathway, if not the primary non-exam pathway.
Well, I think the obvious challenge is identifying supervising lawyers, and it's evident in the data, in calls that I think you mentioned you received, our office received, is people hitting a wall with identifying that. I think finding a way of matching folks, whether it's the State Bar or outside of the State Bar, that would be a beneficial portion of this, or almost a requirement if we wanted to scale it statewide, running the program. We definitely have the infrastructure to do that. We would just need more resources. So it would be something that we could manage, but we would definitely need support and resources dedicated to identifying and vetting supervising lawyers.
But I think that really is one of the key questions for this group, right? Sort of, could you scale it and what does that mean? Because the last presentation that we had was really interesting, I thought, because if you were to sort of think about the supervision that exists in the postgraduate training program, those are all in accredited programs, right? And so we did not have standards we had eligibility standards for the supervisors, but it really just went to how many years in practice and whether you were a lawyer in good standing, didn't have any pending discipline complaints or recent discipline complaints, et cetera. And so to the extent that you were doing this in lieu of an examination, and the committee may want to do this sort of in lieu of curricular requirements or in addition to curricular requirements, but it might suggest that there would need to be some greater standardization of the type of supervision that was exercised, the quality of the supervision, making sure supervisors provide, the following 17 options for what the supervised person does, to make sure that they meet minimum competency, right? Because this would be a supervised program to establish minimum competency. And so there would likely need to be some real structure put around the supervision and potentially some vetting or approval of who appropriate supervisors are, what they look like, in terms of the training that they offer in the office setting.
Thank you. Thank you, Mylene, for your questions. Next, Leah.
Yeah, I just a couple of thoughts. One is this group considering this alternative pathway as a wholesale substitution to an exam for everyone seeking licensure, or an additional option to be exercised by some, and who, if so, who is that some? Are we trying to incentivize, for example, folks to go into careers in legal services? I think when we heard from Claire Salat, that would be her recommendation, that folks who are agreeing to go into certain career pathways would be given this alternative to licensure. So that, I think, is a threshold question. And then thinking about the medical model, residents, of course, receive a salary that's significantly less than doctors. And there is a financial incentive for hospitals to take on residents because, as many of you know, I'm sure you've been seen by residents yourself, they can see patients. So I wonder if part of creating a viable model includes restructuring or rethinking about what the supervised practitioner can do. What would they be licensed and authorized to do so that legal employers are incentivized to hire them? Because they will presumably need some compensation, but they'll be cheaper than a lawyer, and they will be able to perform some functions of a lawyer. So those are a couple of different thoughts I was having as I was listening to the conversation. Thank you.
Thank you. Looks like we're 6 minutes short, and I'm not sure if there are any additional questions. No, thank you, guys. So I can't tell, is that the 3 p.m. start time, the time that they will be joining? I think, Amy, you had sent me an email, or on Audrey?
Two of the attendees are, two of the speakers are in the attendee pool, so we're just waiting for 2. So we might start right at 3, if that's all right.
Okay, then why don't we just take a really quick break to give them an opportunity to join, and we'll reconvene right around 3 o'clock. Okay, thank you. Good afternoon, everyone. That was fast. It looks like we do have all of our speakers. Is that right? I think that's the case. So thank you. Thank you so much for joining us here today. We appreciate your time and wanted to welcome each of you. Next on the agenda is a presentation on the use of supervised practice programs in the law in other jurisdictions or in another jurisdiction. We're joined this afternoon by the following speakers. Please let me know if I mispronounce your name. Corey Gitter, Deputy Executive Director and Director of Policy and Education with the Law Society of Alberta. Leslie, hi, good afternoon. Leslie Small, Senior Director with Professional Development and Practice Support with the Law Society of British Columbia. Erica Green, good afternoon. Erica Green, Acting Manager of Education with the Canadian Centre for Professional Legal Education. Good afternoon. And Ken Osborne, Director, Licensing and Accreditation with the Law Society of Ontario. I'll turn it over to you. Thank you.
Okay, well, I think I'm up first. So hello, everyone. Again, my name is Corey Gitter. I'm the Director of Policy and Education and the Deputy Executive Director at the Law Society of Alberta. I really appreciate the invitation to come here and talk a little bit about our processes in Canada and in particular in my home jurisdiction of Alberta. So just for a bit of clarity on the regulation of lawyers in Canada, because I do think it's a little bit different than it is in the US and in California. The Law Society of Alberta and all regulators in Canada and Canadian provinces regulate lawyers in the public interest. We are not a representative organization, but we oversee the licensure processes, the continuing professional development and discipline of lawyers, among other things. And we tend to say lawyers, not attorneys. So if that sounds weird to you, my apologies. My plan today, as the first of four speakers, I guess, is to talk to you about the processes that students in Alberta must go through on the road to becoming licensed lawyers. So while I'll be talking about my home province in particular, there are many similarities across Canada and how this process works. And I'll give you some details of the process and also point out some of the limitations just to ensure you have the full picture. So to start out, there's probably, I'm going to say roughly 100 to 120,000 lawyers in Canada. In Alberta, and I'm guessing, but I think it's probably in that range. In Alberta, where I live, the province that I live, we have just over 11,000 active lawyers in the province. And each year we have between about 450 and 500 articling students. So when I refer to articling students, these are the people who they're typically recent graduates from law school and are in the process of moving towards licensure. So they register with us, the regulator, as students at law, and they have to serve a term of apprenticeship, which we call articling, as well as complete our bar admission course, which in Alberta is the prep course. And my colleague Erica will be telling you more about that a bit later on. So to back up a bit, to get licensed in our province, there are several steps, and these are pretty similar across the country. First, you need proof of graduation from a Canadian common law school, or if you went to school in another country, you need to have your degree assessed by the National Committee on Accreditation and provide us, again, the regulator, with a certificate that your degree has been qualified. You must complete and pass the bar admission course, and you must serve a term of articles of between 8 and 12 months under the supervision of a lawyer who is at least 4 years at the bar. And we refer to this supervisor as a principal. So articling programs across Canada, as I said, are fairly similar, although they can vary in length and in reporting requirements. Most range in length somewhere between 8 to 12 months. And in Alberta, for many years, we had a term of 12 months for articling, but during COVID, we shortened it to an 8 to 12 month period. And honestly, I expect that that will probably stay for us. And as I said, this does vary across the country, but in Alberta, we have this 8 to 12 month range. And basically, so a minimum of 8 months time period, maximum of 12 months. And this provides some flexibility for the students and employers depending on their own circumstances and the program, their articling program. Because articling, I'm assuming, is a relatively new concept in California, I might just explain some of the broad strokes. And again, I think it's safe to say much of what I'm about to describe holds true across the country, across Canada, as the underpinnings for articling are fairly consistent, although the details will vary a bit province to province, and you'll hear from my colleague Ken Osborne about some very distinct differences in the province of Ontario. But articling as a method of training has been a part of the Canadian licensure process for more than 100 years. Fundamentally, it's intended to be an experiential learning component of a new lawyer's training, during which time they get practical experience on how to be a lawyer. It's supposed to provide the bridge between the largely substantive law focus of law school to the practical, everyday realities of running a law practice and serving clients. As the regulator, we technically oversee and sanction this process in the sense that we set the general parameters for it and make it a mandatory condition before qualifying for licensure. So this means, for example, we authorize who is allowed to supervise the student. Again, this role is called the principal. And we set some objectives on what is supposed to be achieved during the articling process, and of course require some reporting from the principal at the end of the articling term, specifically certifying that the student has met the requirements. So in Alberta, we do that through an education plan that both the principal and the student must agree to at the start of the articling term. And this plan sets learning objectives in several key competency areas. And just for interest, and I apologize for not having slides. I'm not so great with the slides, so I'm just talking at you. But the learning plan sets a few objectives, and these include sets objectives in several key competency areas such as ethics and professionalism, practice management, client relationship management, conducting matters, and adjudication and alternative dispute resolution. So you'll see there's no substantive law connected to this. It's all about practicing. The principal has to submit a mid-year review to us and must, at the end of the articling term, certify that in their view, the student is prepared to practice. So I do want to make it clear, though, that our oversight of what goes on during the articling period is very light. The articling term is a requirement to become a lawyer, but for the most part, it's an employment relationship. So in other words, we don't regulate or oversee in any substantive way the work that the student does or the hours that they keep. We don't have hours requirements for the articling term. The employer or the principal, depending on how they manage their program, may have those sorts of requirements, but we as the overseer regulator do not have those specific requirements. Students are recruited out of law school for articling positions, and often, similar I think to the US, they are first recruited as 1L or 2L summer students. And then those roles will often turn into articling students once the student graduates from law school. And again, as the regulator, we have minimal involvement in that recruitment process. For many law firms of all sizes, having summer students and ultimately articling students is baked into their business model. So they are both serving the profession by helping to train students, but they're also serving themselves by having some less expensive labor and also recruiting talent early and training them to suit their own needs. At the end of the articling term, the principal and the firm will decide whether to keep a student on as an associate. And of course, this is what most students are hoping for. We call that the hire back, or, you know, I've even hired back, and that's a really pivotal time in a young lawyer's career, is whether they're being kept on by the firm that they articled with. So this system has worked well for many students and law firms for many years, but it has not worked for everyone. And knowing this, we are actually in the process right now of taking a pretty critical look at our articling process and trying to assess whether it remains the best way for junior lawyers to be trained. Sounds like some similar questions you're asking in your own jurisdiction. So in general, most students coming out of Canadian law schools seeking articling positions in Alberta are successful in finding that employment relationship. They're successful in finding that job. And firms of all sizes recruit students. Many will work with sole practitioners all the way up to the biggest global firms that we have in the country. But not, as I said, not all students are always successful, and finding an articling position is further complicated if you are an internationally trained lawyer with few connections or supports in the jurisdiction. So in our global world, of course, we have people moving around, and not all of the people who want to practice law in our jurisdictions are trained in Canada, and they are at a distinct disadvantage in trying to find those articling positions, particularly, as I say, if they don't have any connections in the jurisdiction. But again, we know that most students, are 450 to 500, are finding. I'd say about 90% of those are finding positions. But the issue of the shortage of articling positions and the particular challenge of internationally trained lawyers is one of the reasons that the province of Ontario created some alternative pathways, which again, you'll hear about a bit later from Ken. And this is also an issue in my jurisdiction in Alberta, but it just hasn't been quite as acute as it has been in Ontario, which is our largest common law province. We also know that even for those students who do find an articling position, the experience can be spotty and inconsistent, and it depends a great deal on the quality of the principal or other mentors or supervisors that they work with in their firm. So we've known that for a while, but we wanted some harder data on it. So in 2019 in Alberta, we conducted a survey of articling students and junior lawyers under 5 years at the bar. And we asked them a series of questions about how prepared they felt for practice at the end of their articling term. And we also asked them questions about whether they had experienced discrimination or harassment during articles. We also surveyed principals and mentors to ask them similar sort of mirrored questions. Unfortunately, the results were not encouraging. About 50% of the respondents, and I should say we had a pretty good response rate on this survey, so we were confident it was relevant and representative. About 50% of respondents reported feeling unprepared for practice at the end of their articles. And even worse, in some ways, about 1/3 reported having experienced some form of discrimination or harassment, either during the articling recruitment process or during their articling term. The feedback from principals and mentors was also instructive. And while the results were not as stark as what we heard from the students and junior lawyers, it was still clear that there was a lot of room for improvement, and many principals did not really understand their role that well. Well, I have to say, again, we weren't entirely surprised by these results, but it was still alarming to have this data. And it has, in fact, caused us to take stock of the articling system, and more particularly look at how we might create a better, more accountable experiential learning process for our students. And we're doing this in a number of ways. We don't really propose to throw the baby out with the bathwater, because articling has been an excellent way to train many, many lawyers and has value, but it's clearly in need of some improvement. And at the same time, we think it's important to explore alternatives to our traditional articling model and look to other ways to provide that important bridge to practice through experiential learning. And again, I keep picking on Ken because you'll hear from him in Ontario and some of the models that they have, and we are hoping to explore some variation of those models in Alberta as well. In terms of improving the system as it is, one of the first things we're implementing, and we're the first in the country to do this, I think, and we're implementing mandatory principal training. So this will roll out in 2022 and will essentially require anybody who wants to be a principal to take a preparation course on the requirements for that role. The course will include things like ensuring familiarity with learning outcomes, but importantly, it will also include equity, diversity, and inclusion training, unconscious bias training, mentorship training, how to have difficult conversations, key employment law provisions, and things like that. So this is one step we think we can take as a regulator to try to encourage a more consistent experience for students. So because we control the approval of principals, essentially, you will not be permitted to act and be approved as a principal unless you've taken this training prior to doing so. We're also having discussions with a number of law schools about how we might be able to collaborate on embedding some quality experiential learning elements into the law school experience beyond the clinical experiences that are currently being offered. I have to say that I've been at the Law Society, I think about 7 years now, and I just feel so engaged by this work because it's truly really interesting, and it sounds like you're engaged in a similar process in California. But one of the things I've learned is that to shift these norms in our profession requires a real culture shift and a move away from the way we've always done things. Many lawyers in Alberta and Canada generally hold tight to the tradition of articling the way they experienced it. So moving to a different model is challenging and will take time. And in fact, whenever we're talking to our board of directors about this, we've almost gotten to the point of a ban of any recitation of their individual articling experience, because the first thing anybody wants to do when you're talking about changing articling is like, well, when I articled, this is how it went, or I put up with this and I survived, and so on. And we really want to move beyond those conversations into creating systems that are relevant and accountable and ensure competence for today's lawyers, not your grandfather's lawyer. So while I do see changes ahead, I don't think we'll move away from articling completely, as in the right circumstance, it truly can be excellent training, but we need to ensure that it's a safe, consistent, and accountable process, and importantly, that it's not the only bridge to practice. So I think I've used up my time. Thank you so much for your attention. I look forward to your questions at the end, but I think from here, I'm turning it over to Erica to talk about our bar admission program, which is one that is shared across multiple jurisdictions in Canada, and I'll let Erica explain that. Thank you so much.
Thanks, Corey. I am going to attempt to share my screen, but it probably means that all of you are going to disappear. All right, hopefully you can see my slideshow.
Perfect, yes.
Yeah.
Okay, awesome, great, thank you. So my name's Erica Green, and I'm currently the acting manager of education with CPLED. And we deliver the PREP program, which is the bar admission program used in Alberta, Saskatchewan, Manitoba, and Nova Scotia. So this program is another element of what the students require in addition to their articling to be prepared for call to the bar. This program is relatively new, where we took our very first full intake of students in June of 2020. It was a $3 million revamp of what previously existed, a start from scratch to a great degree, to create a new skills-based focused program that was innovative and forward-looking and really meant to assess skills of the students in a performance-based assessment. So we have an underlying competency framework that has probably totaling somewhere in the realm of about 300 total competencies, but they sit in 3 areas: lawyer skills, professional ethics and character, and then practice management and self-management. So the lawyer skills cover all your legal matter management. So interviewing, negotiation, oral advocacy, legal writing, legal drafting, research. And obviously in conjunction with that, the communication skills needed for the students to carry out those skills. Our practice and self-management looks at aspects of running your practice. So trust accounting, business accounting, organization, and also some time to look at self-management for the students and being able to look at work-life balance as well as empathy and dealing with clients. And then professional ethics and character covers our code of conduct, their rules of, our rules and responsibilities as lawyers, and just how to deal with ethical issues when they arise, as well as dealing with client matters. So our program spans over 4 phases, and it's set up as a show, sort of tell, show, practice, perform, and improve, and then demonstrate. So I'm going to talk about each of the phases, but this is sort of the general layout. So the first, actually, before the students even start, we have them do Procertus training, which is software training in Word, and then either Excel, PowerPoint, or Adobe to get them up to speed on those skills, because they're going to be using them not only during their articles, but during the program. Then we have our foundation modules. In total, the program runs somewhere between 280 and 300 hours. So our foundation modules are sort of our base, followed by some time in person, although right now we've been delivering it virtually in our foundation modules. Then the students work in 3 areas in our virtual law firm. And then at the very end, we have our capstone. So that's their evaluation. So phase 1, phase 2, and phase 3 are all just formative learning for the students. Phase 4 is our evaluation stage. So phase 1 is our foundation modules. And like I said, this is our tell stage. So this is where the students get the background knowledge they need to sort of carry them through the rest of the phases. So we have 14 different modules that the students work through. They have interactive components where they do, some testing or quizzing as they go along to make sure that they're gaining understanding. As I said, it covers, all the skills that are set out in our framework. Specifically, we have oral components, written components, research. We also have a module on Indigenous law, cultures, and peoples, which is part of our commitment in Canada to our Truth and Reconciliation Commission, which deals with our involvement with Indigenous peoples in Nova Scotia. We have a practice management module, and at the very end, we have 2 modules that are in action modules. So there it starts to show. So the students will see like a good interview and a bad interview, or a good negotiation, how to do good oral advocacy. They also do some interactive skills where they build like a contract or a letter, or they look for errors. And so this is all starting to be application of what they've learned in the other modules. And this is all self-directed learning. So they have a deadline to have the total components finished, but we don't have specific deadlines for each module. They do at the end of most modules have to write a quiz just to make sure that they've gained the level of knowledge they need to carry forward. So then in our foundation workshops, this is where the students get to really start practicing those skills. So this is meant to be in person for a full week. Right now we're running it virtually online so the students can continue to participate and work forward in their training. They do 5 days, mostly all experiential learning, role playing. So they interview each other. One person pretends to be a client, the other person does the interviews. They do interviewing, negotiation, oral advocacy, legal writing, legal drafting, research. So we have assignments where we work through some assignments they do ahead of time, and then they bring them to the workshop and we work through them, pointing out, areas for improvement, things that are commonly done by, in error by students at that stage. And it also gives them an opportunity to get introduced to the criteria that we're going to assess them on as they go into the next phase. So this is a pretty full week because we touch on everything that's in the modules. So all the lawyering skills, practice management, we work through client management and some ethical dilemmas with the students. And we also touch on cultural competence, bias, and Indigenous interaction with Indigenous clients during that week. So then after they've completed that week, they move into our virtual law firm. So this is back online. We have 3 rotations: business law, criminal law, family law, and real estate. Each rotation is somewhere between 4 and 5 weeks long, and that includes the students doing assignments as well as them being assessed and then getting their feedback on those assignments. So in each rotation, they have somewhere between 5 and 8 deliverables, and that includes interviewing simulated clients, lots of different legal writing and drafting that they do. And all those assignments are assessed by trained assessors. So they're lawyers who have at least 5 years of in practice. And we do a training with them, and then we actually standardize our assessments with them before they actually go in and begin assessing the students. At the end of each rotation, the students get their feedback on their assignments. They have an opportunity to reflect on that feedback. And then we arrange a meeting with a practice manager who is also a practicing lawyer who has at least 5 years experience. And that person meets with the students to help them work through their feedback. Some students are better than others in identifying areas for improvement and really sort of synthesizing their feedback and figuring out what they have to do next. So they have their practice manager to help them work through that. And also the practice manager is available there if the students want to just talk generally or have questions about the practice of law. So they can use that meeting for that as well. So they meet with their practice manager for half an hour at the end of each of their rotations. And we have selected these 3 areas, particularly criminal law and family law, for access to justice issues, as well as areas that have been identified by the law societies, where claims are made or discipline issues are raised. So all of those phases are building up to our capstone or our final evaluation. So the capstone is 4 full days. The first 3 days are simulation. So just like in the virtual law firm, the students are given things to do for a particular client. And again, they'll cover all the skills. So interviewing, negotiation, oral advocacy, legal writing, legal drafting, research, practice management, client management, ethics. They're tested on all of those during the first 3 days in the simulated setting. All their oral assessments are assessed live. So their simulated client will assess their interview. We have trained lawyers sit in and assess their negotiation as well as their oral advocacy. So those are all assessed while the students are actually performing them. Our written assessments are uploaded by the students and assessed offline by assessors who, again, we calibrate or standardize them before they actually go in and begin assessing those specific assignments. Then on day 4, the students do a reflection, and really it's meant to be more of a performance review. So it's an opportunity for the students to think about how did they perform during the program? What areas do they still feel they need to improve on? We have them set goals. And then we have them create their first professional development plan so that they have that in hand when they get called to the bar as their first sort of plan to encourage that, lifelong learning. Everything is changing in the law. And so you sort of need to be on top of that. And this is an opportunity for them to set that first professional development plan, set it up, and be ready to put it in motion as they enter into practice. Just a few bits of information about the program. Our program right now, we have 2 deliveries, one in June and one in December. And this whole program, those 280 to 300 hours in those 2 intakes are delivered over a 9-month period. We also have an accelerated delivery where we deliver the program over 14 weeks. For the accelerated students, the intention is that they will spend 9 to 5 during the week on the program. So unlike the students who are in our 9-month program, who are balancing articling and the program, the students that are in accelerated are focused solely on that program. And we just did our first pilot delivery last June. And we've just gotten approval to go ahead and deliver a cohort, which is somewhere between 30 and 34 students in each of the provinces, coming up in our next June delivery. We found that as far as feedback from students, our assessors and our practice managers, a lot of the students liked the compressed delivery. It wasn't competing with their articles. They could just focus on that. The assessors found the assignments were more well done because there was more time for the student to spend on it. And the practice managers found that the students were less stressed because they had less sort of things to try to attempt to prioritize on their plate. As I said, we're a pretty new program, so we haven't had a lot of deliveries. But as far as our, pass rate, shall we say, I guess, our success rate with students at the end in our capstone, we're running somewhere in the range of about, on average, 85% pass. We probably have another 5 to 10% of students who require a supplemental. So in completing the capstone, we do a holistic evaluation. So we look at their work as a whole to determine if they've been successful. And for students where we can identify an area where they struggled, where they performed well elsewhere, we do have an opportunity to provide them a supplemental in order to give us some more evidence to support that they're ready to enter into practice. And that's the information. I'm happy to answer questions at the end.
Hi, everybody. This is Leslie Small from Lost City, British Columbia. I think I am next, and I am certainly grateful for both Corey and Erica for providing that overview, because I think a lot I can draw on, and so I'm not going to repeat things that they have already told you about, but I'll try and hit some of the highlights and differences that BC does compared to some of the other jurisdictions, and then you will have Ken at the end, who's probably the highlight for the different pathways that Ontario already has. So BC, much as Corey had mentioned, in Alberta, we have a 9 months articling program that all candidates have to get through. It is, the onus is on them to find somebody to act as the principal. And in BC, our requirements to be a principal are 5 years of active practice and kind of no discipline type record. So we are running about 650 students a year, but much as I say, the same process as Alberta, so I won't get into that too much. During the 9 months, there are also the reporting requirements. So instead of an education plan that Alberta does, we have more of a checklist. And the checklist we probably introduced in the early 2000s as a way to try and get principals and students to hone in on some of the things that we wanted them to do and have, again, a real focus on skills over substantive law, with the premise that you went to law school, you understand substantive law, and you can learn substantive law because you've learned how to do that, but the emphasis should be on skills. So much the same as the other jurisdictions, advocacy, interviewing, writing, and drafting. But apart from this checklist, I would say we don't give a lot of direction to principals about the expectations of what that actually means during the course of this 9-month articling term. And much as Alberta and others have found, it's become the business of law. So it really is how do we do this, and not are we really turning our minds to this being an education program or a mentoring experience, at least not evenly across all people or law firms that are doing this task. The checklist that we have, I would say, has become just that. It's a bit of a pro forma now. They get the checklist, they check the boxes, they hand it in. So we do require a report halfway through to say, how are you doing with that checklist? What areas you still need to work on before you get to the 9 months. And again, even those reporting, I would say, has come pretty pro forma. The firms that take students all the time, it's the same letter that you're getting. We'll just change the name on it and let you know how we're doing. The principals do have to, again, sign off at the end of the articling term saying that they have met all of those requirements. So much like some of the other jurisdictions, we're all following suit with each other and trying to catch up on things, but we're also doing a complete review of our articling program. And our board of directors last September said that we're definitely going to be exploring alternatives to articles, and much for all of the same reasons that Corey has already outlined with, is it a barrier? We have 650 students, that sounds great, but we don't know who hasn't yet gotten articles and why, and that's really prevalent in the internationally trained lawyers, where we can't just tap on the law school's shoulders and say, give us your placement rates, because they are very active and all have career services officers to make sure that the students going to their law schools end up with an articling position. We also know about the unevenness in articles. As I said, some of it is just tick the box and hand it in. We don't actually know whether it's quality or quantity of what they're doing, because we say get skills, do these skills, but we don't really articulate what that is. So I think we've all come to the conclusion that we're doing a bit of a disservice here with our outsourcing of what we continue to say out loud is a very, very important piece of learning, but we're outsourcing it without having the right checks and balances. So we're keenly trying to catch up with Alberta on some of that stuff. Probably the other difference here is we don't in BC sign on with the CPLED in the prep course. We have had our own course. And again, unlike prep, it's not a new course. It's actually a course that I think we first introduced in about 1984. And, you know, apart from what actually goes on in the class, the format really hasn't changed since that time. So we deliver our own program. Up until the pandemic started, it was a 10-week full-time in-person class. It does cover some of the same things that the prep course would cover. So students are learning the skills that we've said that are important. So getting exposure to how do I interview a client? How do I draft a contract? And there's assignments and practice and feedback, and then you're assessed on each of those things. I would say, unlike the prep course, at the end, it's not what you might consider a holistic view of whether someone is ready. For each of the 4 skills assessments that we have, students must pass at an average of 70% or more. And we also have 2 bar exams at the end, which are testing on substantive law, and you need 60% on each of those to pass. If a student is unsuccessful on any one of those things 3 times, they are terminated from our program with the expectation that they sit out for a year and then come back, and in some cases have to do it all again, including articling, given the length of time that it may have been since they have been gone. So in BC, we are certainly both looking at our entire program here, including our PLTC, how we deliver, as Corey suggested, going back and kind of doing everybody has to have a law degree to come in, yet we really have no control or say over what that delivery of those things that happen in law school, yet we take it right now at face value, that is a credential that you must have in order to get into the program. And we're starting to question all those things. And I think we're starting to question all those things because we've just been doing it the same way for so long, and recognizing that in 2022 almost, is there a better and different way of doing it, and a better way that we can actually make sure that the future of the legal profession is being trained in a way to deliver legal services in 2022, which is a lot different than when we established even say our PLTC program back in 1984. So there's lots of work going on here, and we look forward to see what you guys are doing as well. So I'm going to keep me short because I think, as I said, I don't want to repeat Corey or Erica, and I think Ken's going to give you a much different perspective on the different things that Ontario has been working on for a number of years.
Thank you, Leslie, and thank you, Corey, Erica, as well, for setting the groundwork on Canada's experiential training programs and licensing processes generally. And I think what you'll probably find with Ontario is that there is some commonality and similarity with some of our programs. Having said that, we've also gone in a different direction, slightly different direction in respect of some of the pathways that we offer for experiential training programs. So I'm just going to take a minute and share my screen if I can do it quickly, because I do have some slides that I thought I would share with you. Does everybody see the licensing process experiential training program slides? Okay. So I want to just sort of work through a presentation. Really, I'm going to focus on the three pathways that the Law Society of Ontario has in place to support experiential training of its candidates in our licensing process. Just by way of an agenda or an introduction, these are the main highlights and areas that I'd like to speak to. The first one, I just really want to reiterate what everyone else has sort of mentioned already, is that in Ontario, the Law Society of Ontario is the regulator of the professions. We're not an association. We do regulate both the lawyer and paralegal professions in this province. I want to talk a little bit about the licensing and paralegal processes generally. I am going to be speaking almost entirely on the lawyer licensing process, as the paralegal licensing process is likely irrelevant to your jurisdiction, but I thought I would mention some of it just in passing. I then want to focus in on experiential training programs specifically and comment on the three pathways that the Law Society of Ontario has in place. And you'll see, with the exception perhaps of one of them, at least two have commonality in some of the concepts and attributes that you've already heard of about during this presentation. I want to talk a little bit about some metrics and benchmarks specifically related to the articling program, and then conclude with some general lessons learned, just on, as I was wrapping up my preparations last night, sort of thinking about some questions or issues perhaps that I'll leave with you to think about as you begin to formulate your ETP considerations. So just by way of introduction, this slide, the only element in this slide that I think that's important for you that I want to highlight is that in Ontario, we have upwards of 56,000, almost 57,000 lawyers who are licensed in this jurisdiction to practice law. That will be increased slightly this year, of which about 35,000 or so are actively practicing. So that 57,000 represents licensees in various licensing statuses, but of that, about 35,000 are actively practicing. We also have almost 10,000 licensed paralegals in our jurisdiction. Ontario is the only jurisdiction in Canada that does license paralegals as well, and that regulation occurred or commenced in and around 2008. In terms of what I do within the Licensing and Accreditation Department of the Law Society of Ontario, I'm responsible for all the licensing processes for both of the professions. And we tend to license 2,400, almost 2,500 lawyer licensees per year. And in 2020, at least 631 paralegals. That number is lower than we've seen in the past. Typically, our paralegal licensing occurs around the 1,000 threshold or so per year, but we did see a dip in 2020. All that to say is that in comparison to your jurisdiction, we still pale to some extent, but our numbers are significant within our licensing processes here within Canada. So moving on, I just want to highlight that the lawyer and paralegal licensing process are fundamentally the same in that they do require academic requirements to be met. They do require a licensing process to be completed, a registrarial process. Licensing examinations must be completed. Both professions, individuals, applicants must be of good character. Lawyers, however, must complete an experiential training program. Paralegals complete that program as part of their academic educational requirements. We require, of course, both applicants to pay fees, and then there is a process for licensure that they complete. This is the lawyer licensing process in sort of a nutshell or a descriptive fashion. I intend on focusing on the 3 pathways which are contained in this description, and they are the integrated practice curriculum, the law practice program, and the articling program. But essentially this slide just indicates that we do have a number of processes in place, which includes academic requirements, the completion of licensing examinations, and a requirement to be of good character in order to be registered as a licensee within the jurisdiction. And now I really want to focus in on the experiential training process pathways. So here in Ontario, there are 3 pathways for completing the experiential training program requirements. And just to step back a little bit to give you some background as to why we have those 3 pathways in place. Ontario in the early 2000s, late 2000s, really was experiencing an ETP crisis. We only had the articling program in place, and we were sensing and certainly feeling that we were unable to address the candidate throughput, essentially, that was coming through our licensing process and requiring experiential training through the articling program. And I'll pull out a metric a little later in the presentation, which might give you some indication as to why that was occurring. But essentially, we were in crisis and we weren't able to service the number of candidates that we were seeing in our process with an experiential training program that was meaningful and appropriate given the single pathway that we had in place at the time, and that was the articling program. In 2013, we began to change that, and we began to evolve our pathways to include additional pathways, and we now have 3. The integrated practice curriculum, the law practice program, and the articling program. What is key, I think, in each of these pathways is that they are all fundamentally comprised or built upon a set of performance appraisal competencies that Erica, Leslie, and Corey have all talked about that are common in each of our jurisdictions, in a sense that we are attempting to inculcate competency based on establishing a client relationship in law, establishing understanding and competency within legal matter management, advocacy, ethics and professionalism, and practice management. So regardless of the pathway that an individual may come through in our process, we are endeavoring to assess these individuals based on a set of consistent performance appraisal competencies. So I want to focus in on each of the pathways just to give you a snapshot of what they entail in case you do have some questions at the end regarding them. The integrated practice curriculum pathway came into place in 2013 initially. It is basically a pathway which integrates the ETP, the performance competencies of the ETP into the academic educational program of the law student. So in Ontario, we have 2 accredited Ontario law schools that have incorporated the integrated practice curriculum into their academic program. The Boer-Alaskan Faculty of Law at Lakehead University, and as recently as 2020, we have a new Faculty of Law here in Ontario, the Ryerson Alexander School of Law at Ryerson University. And these programs have embedded clinical work integrated into the 3-year law degree of the program. And the clinical components are based on a performance educational process and training, requires on-hand assignments, clinical experiences, as well as a 4-month work placement with an improved supervisor. And I should say that I'm going to use the term principal and supervisor at various times. Essentially, they are, in fact, licensees, and I'll talk about the eligibility requirements a little later. They are the same individual. We just refer to different terms depending on the pathway. So again, candidates fulfill the Law Society's experiential training program through the IPC pathway as a result of their graduation from this accredited program, and they are exempted from any further experiential training program contained within the licensing process. This pathway represents a very small component of our candidates, certainly less than 5%, probably more like 2% or so. Lakehead University has 65 candidates per year in its program, and Ryerson, which started in 2020, has 150 candidates in their program as well. So it's a very small component of the ETP, at least at this stage. But I think, frankly, to pick up where Leslie had spoken about earlier, to me, this is sort of the way of the future, integrating experiential training performance competencies within the academic training of a lawyer candidate. The second pathway is the law practice program. This pathway was created in 2014 by the Law Society of Ontario. It is comprised of an 8-month program offered at Ryerson University and a French language program offered at the University of Ottawa Faculty of Law. Both Ryerson University and the University of Ottawa are service providers, technically service providers of the Law Society under contract to deliver this program for the Law Society of Ontario. The program consists of a 4-month training course where candidates learn practical lawyering skills in a simulated, what I call a synthetic law firm environment, where they're actually engaged with faculty who are, in some cases, lawyers, practitioners, engaged in an academic practical learning environment in a simulated law firm environment. And this then is followed by a 4-month work placement component where those candidates are working at law firms, government or courts under an approved supervisor as part of the law practice program. Once again, this program is part of our experiential training process. It is completed after graduation from an accredited Canadian law school and registration with the Law Society for licensure. And on average, approximately 10% of our candidates complete this pathway each and every year. So that's just under 300 candidates or so per year. Without a doubt, the largest component within our ETP, the largest pathway, is the articling program that all of us here before you have spoken about in some way or fashion. Our articling program is very similar to the other jurisdictions within Canada. Our program is a 10-month placement that occurs with an approved articling principal, the purpose of which is to gain exposure to the experiential training competencies that will develop lawyering skills within the profession. As Corey mentioned, the articling program in Ontario is premised on an employer-employee relationship. Articling principals and articling students, in essence, find each other. They come together through various processes, and recruitment occurs, but it's essentially an employer-employee relationship. In Ontario, the articling program can consist of national articles, in other words, articles within Canada, international articles, joint articles, where candidates may actually share experiences within a particular placement. Part-time articles are also permitted so long as the minimum time amounts to what is on the books as a 10-month articling term, but which has been reduced in the pandemic period to a minimum 8-month term. So at the moment, we have candidates that are on a minimum 8-month articling program term, a 9-month articling term, and a 10-month articling term as well too. And approximately 85% of our candidates pursue this pathway each and every year. And this is particularly why we're seeing, or had been seeing, the crisis that we were having, is that it was the dominant and continues to be, to a certain extent, the dominant pathway for many of our candidates. And as I mentioned, as a result of the pandemic, the articling program has been reduced to a minimum 8-month term, and there is still some discussion as to whether that will be increased back to 10 months once we're over this period. In terms of supervision in the pathways, I thought it was kind of important to mention that supervision within the pathways is vetted differently. Within the integrated practice curriculum, it is the universities that are delivering the integrated practice curriculum that are vetting the supervision that is occurring in those pathways, or in that pathway, in those clinical programs. Within the law practice program, it is the service providers that are under contract with the Law Society of Ontario to provide the program that is vetting the supervision of the work placement supervisors in the law practice program. And within the articling program, it is the Law Society of Ontario that is conducting the superintendence of the principals and, to a larger extent, the superintendents of the universities conducting the IPC and the service providers conducting the LPP in respect of supervision. Ultimately, we superintend the pathway. The principal and supervisor eligibility within Ontario is premised on a consistent framework, and much of it is similar to what you've already heard. In Ontario, in order for you to be a principal or a work placement supervisor within the other pathways, you must be actively engaged within the practice of law for 3 to 5 years. You must be an exemplar of the profession, having regard to all the circumstances in your experience in terms of competence, in terms of ethical standards, and general professional conduct and record with the Law Society. And also, you can only supervise a maximum of 2 candidates within any of the pathways. Some of the disqualifying characteristics, again, common across the pathways: you can't be a suspended licensee. You can't be open to a regulatory proceeding that's being conducted by the Law Society or any ensuing court proceeding to that. You cannot be subject to an open investigation within the Law Society of Ontario. And with particular focus on the issue of harassment and discrimination within the workplace, you cannot be the subject of an open complaint regarding harassment, allegations of harassment or discrimination within our jurisdiction. And I do want to distinguish that we are very focused on the issue of mere complaints in regards to harassment and discrimination, whereas in other respects, we see a higher threshold of an investigation being conducted in regards to a particular issue where that might be a disqualifying factor. So just in terms of some articling administration that is done by the Law Society of Ontario in respect of a principal does undertake a bit of pre-placement administration. They must complete an application to serve as an articling principal with the Law Society of Ontario. They must file an experiential training plan, which allows us to determine whether the placement that they are proposing will meet the experiential training competencies that we are expecting for that placement. They must, of course, conduct the recruitment for that placement and find a candidate who is going to be recruited and take on employment at that firm under that principal. And ultimately, they must complete articles of clerkship with the candidate, which the candidate will file with us regarding the parameters of that placement. In terms of the end of the placement, the principal must sign a certificate of service indicating that the candidate completed not only the requisite time, but met the competencies in that experience. And they must complete the record of experiential training with the candidate, essentially recommending to the Law Society that the candidate is ETP complete or ETP pass, indicating that they have successfully completed that ETP requirement. In terms of articling administration on the candidate, there is pre-placement administration that the candidate must do as well too. They, of course, must register with the Law Society's licensing process. They must choose where and how to complete their placement, keeping in mind that we offer national articles, international articles. They must find an approved articling principal, and in cases where there is an international article being considered, the Law Society of Ontario must approve that international licensee or that international lawyer to ensure that they are eligible within our framework to be approved as a principal to support that candidate in that international placement. The candidate must review the principal's experiential training plan, and they must be comfortable with it. and in turn, they must file articles of clerkship with us indicating that they have taken on that placement and they are going to perform it. In addition, there is end of placement administration. They must file their certificate of service indicating that they have successfully completed their ETP experience, and also submit the record of experiential training, which indicates that they are recommended for licensing or experiential training program pass. Just some articling metrics that I'll focus in on. Only about 5% of our private law firms in Ontario are active in articling placements. And again, this was a significant concern for us, and still is to a certain extent a concern for us, that we simply do not see the number of private law firms actively involved in the articling process for whatever reason. This increases to some extent when we add courts, when we add provincial and federal government placements. We tend to see that increasing to about 6 to 7% actively involved in articling placements. In order to sustain our articling program, we need at least 2,000 active principals who are maintaining their eligibility with the Law Society. We have on file about 8,000 principals who are inactive, but who could conceivably reinitiate or re-register their eligibility with the Law Society for work as a principal. Within our program, we need to have at least 2,000 articling placements in order to sustain the demand for those placements per year. Our ETP office, my staff, entertains 5,000 to 6,000 telephone inquiries each year on the articling program only. So I just want to give you a sense that there is an active administration that needs to occur. In terms of some of those inquiries, it's related to administrative issues, it's related to scope of practice, the quality of either the candidate or the principal, and difficulties in placements. And we do encounter those at times, which either require remediation in respect of the principal or remediation in respect of the candidate. Based on our ETP survey from 2021, 86% of our candidates generally indicate that their experience enabled their development to enhance their legal skills. But we do see a lower threshold in terms of readiness and preparation for practice. 63% of our candidates are saying that they're prepared to enter practice. And of course, we'd like to see that higher when we think about the articling program specifically. In terms of some of the things that we could be improving on, I think some of this has already been mentioned by my colleagues: the quality of communication, the quality of mentoring, the quality of timeliness, and the quality and timeliness of feedback within the articling program could be improved. In terms of resourcing the ETPs, I just want to give you some highlights here. In terms of my staff of 38, I have on any given day about 8 individuals who are actively involved in the ETP program in some way. We have 2 accredited Ontario law schools and staff that are supporting, of course, the integrated practice curriculum. We have 2 contracted service providers and their staff supporting the law practice program. As I mentioned, we require at least 2,000 licensees to be actively participating within the articling program. We require upwards of 800 plus public or private legal entities or actors offering placements, either within the articling program or the integrated practice curriculum program or within the LPP. And of course, candidate supports are a feature as well too that have to be considered when you think about supporting your candidate and the principal through the experience. And some of these things within our jurisdiction include the Member Assistance Program and the Discrimination and Harassment Council, which is used by candidates in our jurisdiction. Finally, I want to offer some lessons learned, if I may. Given a large candidate throughput, and Ontario does experience a large candidate throughput like your jurisdiction, we are of the view that multiple pathways may be needed. And we have leveraged accredited Canadian law schools, specifically Ontario law schools. We've leveraged service providers, and of course, we're leveraging the membership, resources of the Law Society, the resources of the regulator to support the ETP. I guess I would leave you with the second observation, which has a number of components to it, and that is be prepared to superintend your ETP pathway, whichever or how many pathways you choose to implement. Build a policy framework. Ensure you have placement and eligibility requirements in place. You may need to determine minimum and maximum time requirements within your placement. You might, as we've encountered, require recruitment procedures to be implemented in order to support active recruitment within your jurisdiction. While we haven't talked about it within any of the Canadian jurisdictions, exemptions within the experiential training program, while not a pathway, does offer an avenue of opportunity to perhaps address the substantial number of candidates that you're seeing through your jurisdiction's licensing processes. Candidate rights of appearance before courts and tribunals. This may be an issue within your jurisdiction. We provide some guidance in respect of this to ours. Candidate leaves of absences, vacations, abridgments of time due to compassionate circumstances. These are considerations within our policy frameworks. Remediation of placements and remediation of principals and candidates may be a circumstance that you need to address within your jurisdiction if you're focused exclusively on the ETP pathway. The withdrawal of articling commitments, either by principals, supervisors, or by the candidates themselves, can create issues for your systems. And there are many, many, many other circumstances that will come into play as you begin to think about your experiential training program pathway. I've kind of gone over time, and I apologize for that. However, I think we all are open to any and all of your questions.
That was very comprehensive. No need to apologize. It's very helpful, and we all thank you for your amazing presentations. And I'll open it up to any questions from the members. And we'll go in order, starting with Judge Lisa.
So thank you for that. That was really eye-opening. I had no concept of how that worked in in Canada, and that was an impressive presentation by everyone. So I appreciate that. So Ken, in his presentation, covered a lot, and he mentioned sort of very quickly, oh yeah, we do barrister and solicitor exams, kind of as a footnote, right? And then he got to these experiential pathways. Well, in our jurisdiction, California, the bar exam is the be all and the end all. So I was wondering, is it kind of a footnote in Ontario, or is it a big deal? Is it a practical exam? Is it just a re-recitation of what you learned in law school? I mean, what is it?
I would describe it as a systematic approach to lawyer licensure. In other words, while there are academic requirements that are in place within all our jurisdictions here in Canada, the Law Society of Ontario has determined that the application of critical reasoning and thinking through the application of a licensing examination, be it a lawyer licensing or a paralegal licensing examination, is not simply an augmentation of the licensing process, but an integral component of the practical requirements for licensure and demonstrating entry-level competence within the profession. So we see it more as a systematic element within our licensing process, and we have not chosen to remove it. And I do not sense any time, at least within my time in this role or my time with the profession, that the Law Society of Ontario will be moving in a direction to remove that specific piece of our system.
So Ken, is that a one-day event? Is it a low passage rate event? Is it a rite of passage? What is it?
Well, it is a licensing event in a sense that candidates are required to complete. At the moment, it's a 4-hour examination that assesses a range of competencies within the lawyer domain, both barrister and solicitor competencies, subjective legal areas. At the moment, it's an online examination. Prior to the pandemic, we were doing large, venued, infrastructurally heavy in-person examinations. So our modality has changed as a result of the pandemic, as well as the length of time for that examination has also been reduced from a 7-hour examination to that 4-hour exam. Typically, it's done within a single day. In other words, there's a part one in the morning, there's a break, and a part two that would happen immediately after. So either a morning or an afternoon activity, depending on the candidate and when they're scheduled for that exam.
So my second question, this goes to the collective group. In California, I took a bar exam before anybody was born. And I've been practicing, off and on, because I was a judge for a long time, for somewhere between 40 and 50 years, right? Could I just start practicing in Ontario, or would I have to do a dance of some sort over there?
So I think you're referring to mobility in the sense that you are a licensee within your current jurisdiction. You're a licensee within the State Bar of California. So in Canada, the expectation would be that you could apply to the National Committee of Accreditation and obtain a certificate of qualification, which is a credentialing or a review and accreditation of your current credentials to determine whether they meet the academic requirements for licensure within Canada generally. And in your particular case, so you may be offered that CQ. You then would enter the Ontario jurisdiction as a candidate, and you would be expected to complete the lawyer licensing examinations and the ETP requirements, unless of course you can make a case for an exemption, which I suspect you may be able to do.
So my third question, and this goes to all of those, to British Columbia, Alberta, Ontario. If California chooses a pathway that involves this experiential analytic, how do you incentivize, I know it's a problem, how do you incentivize practitioners to engage in that?
Maybe I'll dive in, give Ken a break for a second. Well, I guess we don't have, I wouldn't say, formal programs of incentivization. As I mentioned, this structure has been in place for so long. It's embedded in the expectations of practicing lawyers. So I think a lot of lawyers really take a lot of pride in bringing students on and being a principal, in playing that role. They see it as part of their ethical obligation to be part of the training of young lawyers. And I think I mentioned as well, a lot of the business models that they've created are dependent on having those tiered levels and having that inexpensive labor. Now that you have to be careful when you talk about it being inexpensive, because it's a little bit deceiving, because I think that there are embedded costs of training always, but from a client-facing standpoint, it's a lower cost resource. So we are very dependent on the economic conditions of our jurisdictions, and we watch that very carefully. Because, for example, when the pandemic first struck, you will have heard a lot of us reduced the period of time for articles. It's because we were very fearful that it would be we didn't know what the economic impact of the pandemic was going to be early on. We didn't know if law firms were going to be shuttering, because we just had no idea. And so we wanted to, I guess, provide some savings potential to law firms and principals by shortening that articling period, because of course they are paid throughout that period. We also in Alberta reduced, or I guess we increased the subsidy that we pay for the prep program. So there's a tuition that students or their law firm have to pay to do the prep program, but it's subsidized by the Law Society. So we increased that subsidy to reduce the cost to the law firms and students who are paying that tuition. So it's a very economically driven system, and mostly it works out for about 80 to 90% of students, but in terms of there being enough positions. But we're not confident that that's going to be the case going forward. And so it's one of the reasons that we want to look for these alternative pathways, because we are very at the mercy of the economics of the relationship and of our economies. Supply and demand.
And if I could just add to what Corey said, I mean, certainly in British Columbia, you know, we had heard from our students about the very low pay that they get and the number of hours that they work and what that is doing to their mental stress. So we had done some surveys on that, and our board thought that we should get involved with setting some minimum standards of pay and maximum hours worked, but won't do it until there is another alternative pathway, because they're concerned that by introducing more regulations around the articling, it is going to result in a reduction of those articling positions that we currently have. And I think, you know, I know we've had the conversations here, and I'm sure Alberta did as well, when we talk about doing things like providing or mandating some training on who can be a principal. The first thing we always hear is, but that means that there'll be less principals and a reduction in those positions. Some of us would say that might not be a bad thing, because they're not willing to do that. They might not be very good, but it is very sensitive to find that balance.
And so my last question actually goes to Corey, because when you articulated those statistics on harassment and discrimination, I jumped back, right?
Mm-hmm.
A third of the participants that experienced that. And so the last thing, of course, we want to do is to institutionalize some program where we're sending our students into the lion's den. And so is that just endemic in the law practice, or is there some way to steel against that?
Well, we're spending a lot of time trying to figure out ways to steel against it, and developing a lot of education programs, and some kind of 911 programs where we've just implemented something where we will pull someone immediately out of an article if they meet sort of a certain threshold of discrimination and harassment, and we will take on the onus of finding them another placement. And we have a set of roster firms now in place that are willing to provide sort of those rescue articles. But of course, that's reactive, not proactive. I think it's one of the drivers for us to push for alternative pathways, because while the vast majority of principals and environments are healthy, we know that there are many that are not. And I think that the law practice and the power dynamic that's inherent in this type of relationship, and the hierarchical nature of law firms and practice generally just has allowed this type of behavior to go unchecked for a very long time. And so we are doing as a sort of multi-pronged approach, I suppose, that the reactive rescue piece, we're doing a lot of education. We are, the mandatory principal training, and Leslie's comment about the reaction being, well, if we require principals to train, we'll have fewer of them. Our benchers, our board of directors had that very same conversation, but landed on the side of, as Leslie said, if you're not willing to do this and have some training on unconscious bias and have some training on harassment and discrimination, we shouldn't be putting students at your mercy, basically. So it's a really complex issue, and I think that the moment in time we're in right now, there's a lot more willingness to talk about what actually goes on in law firms and with students, which is a good thing. But it's also surfacing things that we really know have been going on for a long time. So I don't have a easy answer for you, but I can tell you that having received that data, it's been transformational for our law society. Like those questions that Leslie has described and others about weighing that balance between favoring something that's going to make life better for the student or not. Our board right now, largely as a result, I think, of those results, is prepared to take those chances to protect students and to force some of this education and other things on the profession because of that shocking survey result. So it's been good in that sense, I suppose.
Thank you.
Thank you. Mylin?
Thanks so much to all of you. That was fascinating. And if I could do it all over again, I think I'd try to get licensed in Canada instead of New York and California. But it's way too late for that. I have a lot of questions about money, but I'm going to try and limit it to just two. And I think both of these will have to go to you, Ken. The first is in relation to the integrated practice curriculum, which is entirely confined within law schools that already have mechanisms for teaching these skills. I'm wondering if there's any comparison between the cost to the law school of running this program through in the two law schools who have adopted it versus other schools that haven't got the curriculum in place. That's my first question about that. And then if I could ask about the law practice program after that, that would be great. Thanks.
So obviously the cost of integrating the clinical experience into the academic component of the training and education is, in the university. It's addressed by the university, and I presume reflected in the tuition that's paid by the candidate to attend that particular university. So really it is it's an operating cost of the university. That said, many universities across Canada include and have included clinical programs within their academic requirements. These two universities have built a program around it and have sought and obtained accreditation from the Law Society of Ontario for that particular pathway. And honestly, I'd like to see more Canadian universities leveraging and building their clinical experiences within their education to come aboard the IPC pathway, because I really do think the commingling of academic learning and practical educational and training is appropriate, is the best experience to take that knowledge and apply it in a performance environment at the time that you are literally building your knowledge and practical base in the practice of law. But it's an operating cost of the university that ultimately is a factor of their tuition to the candidate.
And the law societies aren't subsidizing the schools at all?
No.
Okay, great. And you're preaching to the choir. I'm a clinical professor, so I agree that
and
we need more.
So it's there, it's happening.
Right. And then as to the law practice program, I heard you say that there are 2 contracted service providers. Does that mean that those are those providers of the training and the work placement? And are those existing legal service organizations or law firms? Or I didn't understand what that was. And I also didn't understand how that was funded and whether candidates had to pay for all 8 months.
Well, candidates pay an experiential training program fee, regardless of whether they're in the articling program or in the law practice program. It's the same fee, actually, the candidates pay. And as far as the LPP is concerned, the Law Society essentially tendered a request for services and obtained, based on a scope of work that we wanted defined for the program. And we offered the contract to the University of Ottawa Faculty of Law in respect of the French program, the Programme de Pratique de Droit, which is LPP in French. We tendered the contract to Ryerson University, not the Faculty of Law specifically, but at the time that faculty didn't exist. Ryerson University built a law practice program infrastructure to support its services back to the Law Society in the form of the LPP. So everything is defined by the contract, by the scope of services that we've set, and by our yearly administration of that contract year over year. At the moment, it's a 5-year term, so it'll come up for renewal in 4 years from now, and we'll have to retender. But in Ontario, for example, there are organizations that either provide continuing practice development services to the profession, and have the ability to kind of assemble, much like CPLED has done in other jurisdictions, assemble the infrastructure to provide that service back to the jurisdiction to support their ETP process. We're just looking to the market essentially for those services based on a defined scope of service.
Thank you. Thank you, Mylin. Next is Susan.
Thank you. I have just a quick question. In the US, we obviously have a great deal more diversity in every jurisdiction because we have 50 of them. And all of you seem to know each other and be very coordinated and actually talk about national programs. But Quebec is not here. And I wonder if somebody might address if there is a situation, is this like the US where there's an outlier and they are doing something different? And in full disclosure, I'm married to a man from Montreal, and he's a lawyer in the US, so he's not going to be able to help me here.
Who wants to take it?
I always feel, when it comes to Quebec, I always feel that they're best to represent their interests. But we, all of us, all 14 law societies, I believe I have that correct, provincially and territorially, all of us are members of the Federation of Law Societies of Canada. All of us are integrated in a sense that we are a community of law societies, and all of our processes to a certain extent are very similar. There's a number of attributes that are the same, and that is true within Quebec, although they do have a slightly different legal structure in that province than we do in others. But all of us come together and exchange. All of us are part of the federation. All of us look to the National Committee on Accreditation in terms of the credentialing of academic credentials of internationally trained applicants to our jurisdictions. So we're constantly talking about these issues nationally, across all jurisdictions, regularly.
Yeah. The only thing I will point out about Quebec is that they do have a lot more government oversight than the common law provinces tend to. Sorry, my cat's jumping up on my lap. So it creates a little bit of a different dynamic for them, that because their provincial government is a lot more involved than the common law provinces are. But otherwise, I mean, we know them as well, and as Ken has said, we all gather. We used to gather in person a couple times a year at Federation meetings and so on. So there are differences for sure, but there's still a lot of shared information and collegiality there.
Thank you.
Thank you, Donna.
Thank you. Fabulous presentations, I have to say. I look forward to us getting those PowerPoint presentations from you so we can review them again. I think I took more notes from these 4 presentations than any other presentation recently. I have a couple of questions. I'm going to start with Erica. So you talked about the expedited program, and then the 10-month program, the full-time program, and the full-time. I'm sorry, not 10-month. When is the full-time program? When do you do that? Do you do it after the articling program? Do you do it before? Is it in provinces that don't have articling? How does it fit in the timeline?
So the full 9-month program runs at the same time that the students are articling. So the majority of students are graduating from law school in like Aprilish, May, and they would start in our big June group. And so they're doing their articling and they're doing that at the same time. So those two things are running together. The accelerated program runs for 14 weeks. Right now, we're only running it in June. So they come in June for 14 weeks. They're basically done before Labor Day. And then off they go to their firm. So we encourage them not to work while they're in that sort of accelerated delivery. Of course, we don't have any control over that. As everyone else has said, there's the employee-employer relationship. So we can only encourage that. It is a lot of work. So it's, crammed into such a short period of time. So we really try to encourage employers not to have the students doing any work in the firm until after they finish the program.
Gotcha. Yeah, I got my question reversed. So that was what I was talking about was the accelerated program. So you encourage them to do the accelerated program first and then do their articling, but it could be that they are doing them simultaneously.
They could be. Like I said, it would be very difficult, I think, for the students to keep up, because basically the time, like to take those like 280 to 300 hours and put it in that 14 weeks basically means that it's like a 9-to-5 job, Monday to Friday.
And could they do the articling program first and then do the accelerated program?
They could, if they wanted to do that. I would say that most students want to get their bar admission course or program and the test part, the evaluation part, out of the way, right? Out of the way. They could. The only thing that the students have to be careful of is just like the completion requirements for the various provinces, right? So probably if they do them like one right after the other, they're probably safe. But if there's any gaps, they could exceed the time frame they have to complete their articling and their course to be able to be called.
Gotcha. And I know Leslie mentioned that British Columbia has their own prep course. I think you said, Erica, that there were about maybe 4 or 5 provinces that use CPLED?
Yeah, so we have 4 right now. The prairie provinces, so Alberta, Saskatchewan, and Manitoba, and then one of our Atlantic provinces, which is Nova Scotia, which is originally where I am from. Nova Scotia had been using part of the old prior version of CPLED or PrEP, and so when they converted to the new program, Nova Scotia decided that they would come on board as well. So we have 4 right now.
And do the other provinces have their own, or do some provinces not have any program like this? It's just articling and then licensure.
Every province that I'm aware of has some form. So different varieties, right? Different amounts of time. I think we just recently met with Newfoundland, and I want to say that theirs is like 7 weeks. I think it's 5 or 6 weeks in PEI and maybe similar in New Brunswick. And I know that in Quebec, they have like what they call the Bureau, and they also deliver a program. So everyone has some form of program, varying lengths and similar but varying content.
Great. 2 more very quick questions. Thank you, Erica.
You're welcome.
This is for Corey or Ken or Leslie. Can a principal have more than one candidate? I'm just trying to think how we would scale up in California.
So certainly in BC, we have limited it to 2 at a time.
And that's the same in Ontario, maximum 2 candidates at a time.
Yeah, that's generally the same in Alberta, although we have in some occasions allowed for more, particularly if it's a very focused program. So sometimes in like a clinic environment or something, we might have one designated principal, but with the knowledge that, they have a lot of other resources available to them as well. But it requires a special dispensation, I guess.
Can I hop in here? Not that I should speak on behalf of Nova Scotia, but formerly being employed there, they actually do. It's a one-to-one lineup, but they also have a setting where basically like if you have a large firm, you can have one principal who's sort of the main individual, but you can have a student, that principal can have a student, equivalent number of students for individuals who would qualify. So if you had a large firm who had like 10 people who could actually qualify as principal, they could take 10 students, but on their record book, there would be one principal. That was the person who's responsible to report back to the Law Society.
Okay, and then I think my final question. So Ken had mentioned the barristers and the solicitors exam. So one, or I guess it's a two-part question. One, when is that exam? When do the students take that exam? Before or after the articling program? And two, do the other provinces represented here also require an exam?
So in Ontario, candidates can take the examination at any point in their time within the licensing process. Candidates in Ontario have 3 years to complete the requirements of the licensing process in total. On average, candidates will complete it in about 13, 14 months based on the older 10-month minimum articling term. But candidates can take the examination at any point. Typically, they will take it before doing the articling or an ETP or the LPP, just because they want that out of the way so they can focus on the practical components.
BC certainly has a barrister's and a solicitor's exam as well. We hold them regularly kind of at the end of our professional legal training course, but we don't teach to the exam. So while the course is 10 weeks and we have them at the end, we're very clear that we're not teaching to the exam. So in theory, students could take the exams anytime they wanted and then shave off a little bit at the end of that course. But they get so focused, I think they assume there's going to be teaching to it, that they all do it that way. And with our professional legal training course, we hold it 3 times a year. So most want to be in our first session in May because they're coming right out of law school, right into the course. That's certainly the most popular, which means it's always oversubscribed because we've very much been in person. And even when we changed to the pandemic, we said this was not an online course. This was a virtual classroom. So we kept the classroom numbers the same. So it means that some will start articles and then maybe come to our February session. So they're kind of right in the middle, which I think makes it harder for some students to then not to go to work because they're in the middle of doing some files and to leave for 10 weeks. Some will do it right at the end, but those ones don't really want that either because their fear is what if they fail something and they've already done the 9 months and then they've got to hang out in this a bit of a limbo stage because they don't get to write again until the following session. So there is a bit of a gap.
And just speaking for the CPLED, the prep jurisdictions, there is not a substantive barrister and solicitor exam. We rely entirely on the prep program and the capstone assessment and those processes for our assessment. There is, of course, substantive elements in the prep program because you're doing practical assignments in criminal law and family law and real estate and so on, but we do not do a substantive test. We sort of take the view that you're supposed to come out of law school with all that stuff, and our job is to bridge you into the practical. So none of the prep jurisdictions have a substantive barrister and solicitor exam.
Yeah, and Nova Scotia had a substantive exam before they rolled into prep. So they gave up their exam for the benefit of being able to have that evaluation of skills.
Super helpful. I appreciate you all responding so we could get a sense of how it's applied similarly or differently in each of the provinces.
This is probably covered, I'm gleaning from what you've said, but it was mentioned that some of you are in the process now of looking at your programs, evaluating them, and determining whether you're going to develop alternatives. I was wondering if you're going to the extent you have the examination, are going to be looking at that as well, or if that's sort of, you're considering that as a fixed component of your existing program.
Well, speaking for Ontario, we have that as a fixed component of our licensing process. We review our examination obviously as an attribute of the licensing process. So we assess its effectiveness, the integrity, the elements of the exam, and so on. We have a systematic process for developing, designing, and delivering that exam. At the moment, it's a fundamental component of our licensing process. Some of the discussions that we are having in this jurisdiction is whether a skills component or a skills assessment also needs to be added to the experiential training program requirement, so that there is sort of a capstone, to use the CPLET language, a capstone to that experiential training program requirement as well.
And certainly in BC, we think of it as one program. So we call it the Law Society Admission Program, and that just means articling and PLTC and the exams. So given that we have said that we're going to do a complete review for our program, I would say right now, everything is on the table and up for grabs. I have no idea where it's going to kind of shake out at the end of the day, but I would say it's all on the table for review.
Thank you.
We just spent a whole bunch of money building prep, so we're sticking with it for a while. But the experiential piece is where, in Alberta, certainly we're really looking at where we can create alternative pathways and enhance what we have. But prep, we'll stick with prep for foreseeable future.
Well, and the commitment from CPLED is that prep every 3 years of delivery will undergo a full overhaul. So we're already looking at surveying stakeholders, obtaining information, evaluating our competencies, and having in June 2024 a revised program that addresses all that changes and obviously addresses what we've learned so far to make the program even better.
Thank you. Judge Reitzer?
So Leslie, is the exam portion in British Columbia also a half day like the exam portion in Toronto or Ontario rather?
Yeah, so ours is 2 exams that we break out, 1 barrister, 1 solicitor. They're 3 hours in length each. You don't have to write them on the same day. They're usually written 2 or 3 days apart.
So people do both?
Oh yes, you do have to do both.
Oh, okay.
And you have to
can't
pass
pick
both.
one. Okay, all right.
Thank you. Are there any additional questions? Doesn't appear that there are any. Again, thank you so much. This was a really terrific presentation by each of you, and we are thankful that you participated and appreciate your time here today.
Well, thank you for the invitation.
Thank you very much.
Thanks for having us, and Audrey knows how to find us if you have any more
Okay.
questions.
I will find you. Thank you.
We'll be following your approaches. Thank you.
Thanks, everyone.
With
Have a nice
interest.
evening.
Thank you. So we'll move on to the next item on the agenda, which is a discussion of next steps for the next meeting, which is scheduled for January 4th. And we have about a little less than 20 minutes. Not sure. At this point, it appears that we will be meeting as a subcommittee again for the exam subcommittee. And I think it makes sense at this point also for us to reconvene as a subcommittee before presenting any recommendations to the larger group. At the end of the prior subcommittee meeting, we inquired to see if there were any, similar to last time, if there are any additional areas that you'd like for us to bring back additional information or presenters. So I'll open it up to see if you do have any ideas that you would like to hear more about for the next subcommittee meeting.
Justice Guerrero, this is Amy Williams.
Yes.
I have to say that today's presentations were the most compelling for me and resonated the most with me, seeing the difference or comparison contrast with the other professions was really helpful, because I keep drawing comparisons to those, doctors. We may not be operating, but we have the same responsibility. We have the same level of responsibility and fiduciary duty to our clients when we're representing them. and a catastrophic mistake by an attorney. Someone could lose their home, they could lose their business, they're just as impacted as if a surgery has gone wrong. So I felt today's presentation, the information that was provided for me really resonated and really is helping me to start taking shape my thoughts regarding an approach without an exam. Because I have to say, when I was first assigned to this committee, I thought, oh, how's this going to work? Because I am very much for an exam. But now I am seeing the other side. So I appreciated today's seminar.
Thank you, Amy. Judge Reeser, you do have your hand up, but I think that might have been a mistake.
Yeah, I haven't lowered it yet, but it's,
okay.
it's the blood is now rushing out of it. So
thank you, Mylin.
I don't, I second everything that Amy just said, and I don't feel a need. I'm happy to learn more about other areas. I feel a need to sort of start compiling the information that we already have and trying to organize it.
Yeah, and map out an approach.
Yeah.
Yeah.
So that's all I wanted to say. And I don't know whether we do that, you know, is that something we do together? Is that something that, you know, one of those extremely competent people at the bar does for us? I'm happy to do it either way.
So I think Justice Guerrero, Audrey's got a few questions. We were going to conduct a straw poll just to see where people are leaning, because I think that might help us figure out the answer to Mylin's question, and a little bit the answer to your question in terms of, you know, based on where people are leaning, what additional information do we need to bring back to the committee, or what framework do we need to sort of create for the committee to respond to? And so, Audrey, do you have those straw poll questions?
I have them. I don't know, Professor Boxton, if you want to share before I start reading.
I just had one quick comment, and I agree with everything that's been expressed today, including how very helpful everything today was. And the struggle I am having is the conflict between the blue ribbons, big picture, sort of make a recommendation kind of approach to. And on that, I think it's easy for me to say that I really enjoy seeing all of the non-exam alternatives and that we will find a way forward for California within those. On the other hand, I struggle against that big picture with the small scale. Are we supposed to be considering logistics and scale and all of these things, which are clearly going to be large issues in a large state like ours? But to a certain extent, I feel like maybe that's what your straw poll is about to address, is what are we doing first? Big picture, yes, we're going down this path, or how much logistics and scalability has to be established first before we can feel confident in making those kinds of recommendations.
Well, there is a tension. I do think that I'm anticipating the questions might help narrow what we'll probably be discussing at the next meeting. So maybe we can, if you have additional questions, we'll circle back after we conduct the straw poll.
Well, go ahead.
I mean, my instinct is, of course, we need to try to get some kind of cohesive direction. What was really comforting about today is to know that there are analogous groups of folks, including a fairly large jurisdiction, right? Ontario is, you know, that's not just Ottawa, that's Toronto. I mean, there's bigger cities there than in California, right? So at least in terms of Toronto. So the question in my mind is, you know, where do we go? Should we try to formulate something? But we can now leverage the experience of these other entities on some of the larger picture questions. I should say some of the background questions that Susan's been talking about. You know, how do you accomplish this? You know, how do you roll it out? While we will have a if we choose a direction of alternate pathways, there's going to be a big buy-in piece with the state bar. That's probably not necessarily our responsibility, but we can't ignore it. The fact that when one of our presenters today talked about creating a culture change within the local bar, we're talking about something even more radical in California. So I think we have to be mindful of that, but at the same time, do what's right for, our citizens, right? And our lawyers or prospective lawyers. So we just have to do the right thing.
Okay,
We have a unanimous agreement with that.
I'm going to read the 3 questions, just so you know what I'm going to ask, and then I'm going to read each of them separately. And when I read one, if you could raise your hand, then I'll count, and then put your hand down so I could count. And you can vote more than once, but you understand what I'm saying. Just vote and then put your hand down so I can count it. Okay, so the 3 questions will be, are you in favor of adopting a non-exam pathway to licensure? Should there be more than one non-exam pathway like we heard from the Oregon Task Force? And the 3rd one is, should a non-exam pathway be accompanied by an exam pathway? So those are the 3. So I'm going to read the first one and I'll look for your hands. Are you in favor of adopting a non-exam pathway to licensure? Oh, real hands. That's nice. I will take both real hands and pretend hands. Okay. Okay.
So do we want to make sure that Amy Williams has an opportunity to raise her hand too, because I'm not sure if she's.
I'm not there yet. I'm going to vote no on the question.
Perfect. Okay.
So, let me make sure I've got the hands counted. If they are still up, I'm still counting for the first question because I wasn't sure. So please put them up again and I'll tell you when to take it down. I don't want to miscount. Okay. All right. Should there be more? So you can put your hands down, please, so we can have it for the next one. Thank you. Should there be more than one non-exam pathway like the Oregon Task Force? Okay. Please keep them up. Okay. Can you please put your hands down? Thank you. Last question. Should a non-exam pathway be accompanied by an exam pathway? Okay. Okay, I think I've recorded. If you, I don't know if anyone has any thoughts or feelings they'd like to share after voting, but I've got your hands.
This is Amy. I'm still not quite 100% convinced that it should be that the exam should go away completely and that we have only a non-exam pathway. I'm not there yet, but I can see how we can offer a pathway that doesn't require an exam. That's where I'm at as of right now.
And this is Esther. I know I haven't spoken very much in the course of these meetings, but I share the same sentiments as Amy. I have the same concerns, but I'm open to the alternatives that were discussed today.
And I would say in response to the sort of more global question that was asked beforehand, I believe it was by Judge Reeser. I think part of what this group is still going to need to grapple with, right? Those fairness and equity and accessibility questions, which include things like scalability, right? And so this group is going to need to come up with a recommendation of either, if the group, let's just sort of make assumptions here, right? So if the group were to conclude, yes, we want to proceed with, with one or more non-exam pathways, is it, but only if they're fully scalable, or irrespective of if they're fully scalable, thinking about how it might, and then figuring out sort of the curricular requirement, is it within law school, is it post law school? But ultimately we want to come up with, I think, some real details on what the pathway would be, and if what would the structure be on getting supervisors if it's a post law school pathway. Who would be responsible for, I'm going to adopt the phrase superintending the program. Who'd be responsible for that? What, would there be requirements to, educational learning objectives that we would need to set, like some of the folks from Canada talked about. I think sort of having all of that background into what we're looking for in a non-exam pathway, and going through that discussion of does it create challenges for certain populations, whether based on race, gender, disability, law school type, or law office study program that you complete. Right, and sort of figuring out all of those issues. But I think that is a big part of what we need to figure out. Are we comfortable creating a program that maybe is sort of more narrow and only the top 200 people who apply, can get into it, right? Figuring out all of those things to address those kinds of scalability issues.
Ms. Reitzer?
And I also don't want us to lose sight of, there's another alternative pathway that we haven't talked about today necessarily, and that is if you're a practicing lawyer in another state, and you haven't had for X number of years, whether it's 5 years, whether it's 7 years, it's not so much the number of years as it is the reality that those people ought to be able to come to California and practice law without doing the minuet.
It was very interesting listening to the other point of view from the Canadians, because I actually spent part of my year in British Columbia. And 15 years ago, when I first bought a house there, I looked into licensing in British Columbia, and the process was so convoluted. And I'm thinking, I already have 10 years of litigation under my belt, and you're asking me to do what? So I can agree. And I'm not worried about those individuals who are trying to seek some sort of reciprocity because they're licensed in another state and they have a number of years of experience under their belt. I am only really concerned with those that are either just graduated from law school or did not go to law school and are just attempting to apprentice. Those are the individuals that I think are at most risk for mistakes.
Concur.
So I think Justice Guerrero, at the start of the next meeting, we can sort of go back through the questions that we set up, that we established at the last meeting, just as a reminder of the various sort of topics that we need to consider: scalability, fairness, accessibility, cost, all of those issues, right? Portability and reciprocity for those going to law school within California and those coming to California. We can just sort of start by reminding ourselves of those issues. And then we need to figure out sort of what additional information would help the committee narrow down sort of the options that they are in favor in, because there was fairly high counts, I think, on each of the questions that Audrey asked.
Yeah, I mean, I get the sense that it'd be nice to be able to put together some type of or at least start developing some concrete ideas of maybe starting with one program first before deciding whether there are additional alternatives. But then addressing all of those questions that were mentioned, that you've mentioned just now, and that were in the prior presentation, really what it should look like, and I think people are open to the possibility of having an alternative. But then when we get into all of these additional details, that might either change our views or I don't know that I'm not suggesting that you should change your mind about the possibility of having an alternative, but I think it's helpful to start mapping out what it'll look like in order to inform what type of recommendations we would make.
So let me pose one more question for a straw poll that just occurred to me, Justice Guerrero, as you were laying that all out, which is getting a sense of the group of if you are, of your preferences between these two. One would be a pathway that includes an experiential requirement and a curricular requirement within the law school setting. And the experiential could, basically the involvement of the law schools in setting curriculum and potentially doing clinical programs or otherwise, or something that is sort of irrespective of the law school education, an experiential requirement that begins after law school and that doesn't have any sort of law school involvement. So first question is law school. First option is a program that at the very least sort of begins in law school. And option two is post graduation that doesn't involve law school. So hands for option A that involves law school participation. And hands for option B that does not involve law school participation.
I voted for both.
Right. A lot of, are you saying preference between the two?
Yeah.
Or are you saying, yeah, so, because, I mean, optimally, you want to gear it towards a law school curriculum, right? But we have this whole, I don't know how many thousands of people are stuck in the corral, right? Of post-law school who are now, we'll say only prospectively, we're going to start doing this. Why would we discriminate against those people who've, put their lives into law school and haven't passed the bar yet?
I agree. I think that having this available while they're in law school, they're already a captive audience. They're there to study. So initiating some sort of practicum program while they're in law school, particularly for the 3Ls, maybe not the first year, or maybe even not the second years, but definitely for 3Ls, they're quite capable of being able to handle something like that.
I don't know, Mylin and Susan, do you have your hands up for additional comment?
Mine was up in relation to next steps, I guess, and sort of a request. I really, really loved it when we got a PowerPoint or a slide with pros and cons of several different options. Mm-hmm. And I feel like this conversation that we're starting to get into right now, to me, it feels really premature. The question of within law school or out of law school, like that's a huge question. We haven't talked about a lot of different pros and cons related to those two things. So even though it's a straw poll, it feels like it feels premature to me. And I guess I would not just a set in stone pros and cons, but something that we could then also add to, because I've got a lot of thoughts about this, because a lot of what we're talking about is very similar to externships, which is what I do and have done. And there's a lot of information out there specific to California that we could add into the discussion maybe before we start picking which general path we're going down.
Okay, thank you. And Susan?
I'll second Mylin's comments. I agree that a great deal of the next steps feels premature until we have some more structure. But what I did want to add, just for the benefit of those who are not current, several of us are currently teaching in law schools and run these kinds of programs. I think it may not be that obvious to others, particularly folks like myself who went to law school a long time ago. Schools already do all this. I mean, I can't tell you the number of slides we saw today that my school is already doing in experiential classes, in live clinics, in everything. And it's a very different experience today. And I think it might be very helpful when we start getting into the details to rely a little bit on our law schools and maybe have an opportunity to showcase more of just how very much experiential learning has changed and how very much of this we're already doing. And it might neatly path into something.
Amy?
So we're talking almost 20 years since I've graduated. I was not prepared when I graduated from law school in no way, shape, or form. And the only reason I was able to survive was because I, on my own, initiated 2 internships with the LA County DA's office and with the California State Attorney General's office. If I hadn't had those 2 internships that I sought out myself, in fact, I brought those programs to my school, I would have known nothing. The one practicum course that was offered was 1 semester and still was woefully inadequate had I passed the bar and just dove into work. But luckily I had a year where I traveled, so I was able to remove and really study. I see some of these other law schools that I've participated in some of their extracurricular events, and I don't see that their curriculum offers a robust way for the students to, at least the 3Ls, to have a real true understanding of what they're getting into post law school. They've been reading books for 3 years, maybe a mock trial, but not everybody does mock trial because it's an elective. So I feel I still maintain that law school curriculum in this respect is woefully inadequate. And I don't know that I think that there should be some sort of oversight on the curriculum that does go into law schools regarding the subject.
So maybe it would be beneficial if we had a representative ABA approved law school, California Bar Accredited Law School, and registered law school come to present to us, because my law school experience is much older than Amy's, I'm afraid to say, and hear from hear what kinds of programs are being offered that meet that as Mylin had said, that really sort of do address some of these experiential requirements and what kind of curricular requirements, what the clinical programs are, hearing about trial advocacy classes, all of that might be beneficial to us.
Donna, what would be interesting as far as metrics? It'd be interesting if there was a survey on 3Ls at graduation, so like July of a graduating year, and asking them, do you feel prepared to dive into a court or transaction, whatever kind of law they might practice? Do you feel prepared 100% to be able to do this work and do it well without mistakes? And then another survey 2 years out of law school. Where are they? Do they feel prepared? Where are they in their career 2 years after law school, 1 year, 2 years after law school, maybe even 3 years? Do they feel adequately prepared to practice law? I'd be interested in those metrics.
Having seen so many 2nd and 3rd year lawyers over the course of time, right? The 2nd year lawyers think they know everything, but then the 3rd year lawyers know they don't know everything. So the numbers will go up and then go back down again.
Yeah, I got to tell you, it wasn't until I was 5 or 6 years out where I really started to feel comfortable and say, okay, I can do this. No imposter syndrome. I know what I'm doing. But I also had a lot of help. If I didn't understand something, I had a lot of mentors that I could go seek help from. But I shouldn't have to do that. that training should have already been there.
Well, I know I don't feel 100% prepared now, so that seems like a bit of a high bar, but we can certainly get a sort of look at how we might get some input from the students as well.
Susan?
Just to follow up on Donna's point, you might be able to just simply send around the current regulations for what's required. For example, today, the ABA has a requirement. All the ABA schools have to have experiential learning. This ship sailed years ago. So while it was not present for any of us, it is very much present today. But what I would appreciate knowing, because I'm captive to my own experience here at an ABA school, is I would love to hear what the California and registered schools have for their requirements, because I am less familiar there, and that would be very helpful. And I'm thinking that might be a matter of just sending around documents.
Yes, I think we could prepare those.
And I know Jackie is on our subcommittee, Gardena. She's just not here today, but she's a non-ABA California accredited school.
Yeah, we can certainly pull that information together. I think we've got sort of enough to sort of rattle around in our brains a little bit. Justice Greer will circle back with you maybe next week in terms of sort of planning an agenda based on all of this input before we lose sort of the momentum from today's meeting and forget all the important points. So
yeah, there's a lot.
That agenda.
Totally agree. I think that's a good approach. There is a lot to absorb from today's meeting. I'm hopeful that we could get just like we have in the past, some written materials to look through as well.
I'll send those.
Okay,
As soon as I
thank you.
get the rest of them, I'll send them out to you.
Great. Okay, well, thank you. I will then wrap up, and we've gone through the specific items on the business agenda. Is there any more business for today's subcommittee meeting? Okay, I see no hands. So today's subcommittee meeting is adjourned, and our next meeting will be on January 4th, which is after the holidays. So I hope you all have very pleasant holidays and stay safe, and I look forward to seeing you in January. Thank you.
Everyone, thank you.
Happy holidays.
Happy holidays.